Thank you very much for joining us here again at Tyrant Slayer Studios. We are bringing you very much requested updates on a very serious and egregious set of circumstances here in the state of Connecticut and throughout the nation. We're going to be talking about foreclosure and racketeering schemes to the tune of millions of dollars. There's mayors, there's judges, there's corrupt entities operating in private capacities in conjunction with their public offices, essentially stealing people's houses all across Connecticut, all across the nation. They think they've got some sort of legal loophole to work within, but the Constitution very clearly states otherwise. And those akin to the knowledge and the power of the Constitution, those aware of our rights and our laws and inclined to be aware of what's going on and help others become aware of what's going on, are smart enough to know that this is dead wrong. You know, that this is the equivalent to treason. You know, this is a very serious common occurrence happening all over Connecticut and all over the nation. 67-year-old women are being forced to sleep in their car. They owe $12 on a $600,000 property. And the judges and the state and every other corrupt entity involved, seized that property illegally over sometimes a debt that these people are completely unaware of, which makes it even all the more bewildering. It's a very complex sort of story and situation. We've been fortunate enough to hook up with some of the victims in the state of Connecticut, which we have brought to you here before. If you're new to the channel, we've been known to dub this as capious mortgage fraud, title laundering, securities fraud. There's a whole list of things wrong with this on every level. And there's nobody that I know who can explain it better and give you a very clear, simple, concise explanation for it all, and even delve into what our legal recourse is. How can you protect yourself? That's what we're going to be focusing on here today. How is this man protecting himself? What has he found in his experience in all of this trauma to be effective and not effective? And if his strategies haven't been effective, what about them have failed and why? We're going to dive into all of that here with Mr. Andrew Pritrchard. This is a roughly 30-year resident of the city of Norwalk, Connecticut. We were live at his house. The date of eviction is what they call it, but the illegal seizure, the siege upon his house took place on August the 29th of 2022. And, it's been a nightmare for this man and his family since. It is my understanding that this man has lost all of his property, his belongings, none of the systems that are supposed to be in place for him to apprehend any items removed from the property that's been illegally seized have been followed. Nothing is this has been a nightmare, to summarize it, really. There's no better way to put it. He's lost everything, and it's still lost, and things are still being adjudicated. Things are still in motion. There's still litigation, and that the house is being put up for sale to numerous entities. And in fact, unless I misunderstand something, there's multiple people who think they already own the property. So Andy's going to introduce himself a lot better than I just did and dive right into it. We're going to be joined by Mr. Al Cuzio. He's another great legal mind here in the state of Connecticut. And we're just going to hit this like 10 men. Al, say hello. Andy, you have the floor.
Hello.
Hey, welcome.
Hey, Andrew.
Just to correct a couple of things, just to update, we have found some of our belongings, most of the stuff has been damaged. There's also still a lot of stuff missing. And as a matter of fact, there's still a sizable amount of stuff still on the property, which is our property. So I'm not having a problem with it sitting there. Really, this podcast and what I want to do in this podcast is not talk so much about my case. And it's not about my case. I want to talk about some of the big picture items here because my case, along with everybody else's cases here in Connecticut, really demonstrates the foreclosure racketeering that's going on. But people need to understand the scale of this. What happens is people look at this thing as if it's just with them, just in the small part of, let's say, just within the state of Connecticut. This is a much bigger beast than that. And when you start to understand that, then you understand the big money that's in play, the laundering that's going on. You flip these properties, you can clean a lot of dirty money when you're doing this. There's a lot of significant things going on. And let me put it in this kind of perspective. And I'm not saying these are the numbers, but just for the sake of it. My rough count of the number of judges in the state of Connecticut and judge referees and everything else is about 240. So if I'm a criminal boss and I say to myself, you know what? I think we can control Connecticut. I just need $240 million. And then I can do billions and billions and billions of dollars of stuff there. I just need to get $1 million to each one of these judges in a nice, smooth way where they're not in any sort of trouble. And if you start to think like that, you start to understand and you can see how some of these things all come together. Now, I'm not suggesting that I don't have proof of those sorts of numbers and stuff, but and I'm simplifying, but there's big money involved here. Don't get confused here. These are banks in 08, 09. They had no money and they went right back to the same system, and their justification was, we got to fill the coffers. So they went right back to it. Anyway, what I want to do is play a little bit of a professor here, and I'm going to do it using my court docket because I put certain items within my case that people can refer to. You can pull up my case at the Judicial branch website as Tim's showing us right now. My case number is click on civil there, and then you can go by docket, or it's hard for me to see that. Yeah, and right there you can put in the location is Stamford, which is FST. If you highlight on that, it should, you get FST. The year is it's CV 15. The year is 15. The docket number is 602-6844S. Yeah. And if you hit on that and do a search where it says search, it should bring up my case.
It should.
Unless
it's loading
right now.
It's loading. Here we go.
All right. Okay, so this case has, almost 900 filings in it. But what we'd like to do is we want to go to docket number 459 first.
I'll make this a little bigger for everybody.
And if you can open that up.
I have it open. I'm going to have to reshare this screen, so just give me a moment here. I didn't realize that wouldn't just carry over for us.
Sure, while you're doing that, I'll start reading. This is titled Problems in Mortgage Servicing from Modification to Foreclosure Hearing before the Senate Committee on Banking, Housing, and Urban Affairs, 111th Congress, November 16, 2010. Testimony of Adam J. Levitin, I think I'm saying his name the right way. Adam J. Levitin is the professor of law at Georgetown University Law Center in Washington, D.C., where he teaches courses in structured finance, consumer finance, bankruptcy, contracts, and commercial law. Housing finance is a major focus of his scholarship. Levitin holds a JD from Harvard Law School, Master's Columbia, AB from Harvard. He was awarded the American Law Institute Young Scholar Medal, blah, 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 blah.
Oh, yeah.
Professor Levitin has served as the Bruce W. Nichols Visiting Professor at Law at Harvard Law School. They get his credentials are off the chart, right?
Mm-hmm. Mm-hmm.
Basically, in his testimony before the Congressional Committee, Professor Levitin testified about what he and other academics and some of the colleagues commonly refer to as the securitization fail scenario in his testimony. So this was the Senate and everybody hearing hearings from all the great experts about what went wrong, 08, 09, and everything else. And in his statement, he says this: the mortgage foreclosure process is beset by a variety of problems. These range from procedural defects, including but not limiting to robo-signing, to outright counterfeiting of documents, to questions about the validity of private label mortgage securitizations that could mean that these mortgage-backed securities are not actually backed by any mortgages whatsoever. While the extent of these problems is unknown at present, the evidence is mounting that it is not limited to a one-off cases, but that there may be pervasive defects throughout the foreclosure and securitization processes. The problems in the mortgage market are highly technical, but they are extremely serious. At best, they present problems of fraud on the court, clouded title to property, and delay in foreclosures that will increase the shadow housing inventory and drive down home prices. At worst, they represent a systematic risk of liabilities in trillions of dollars, greatly exceeding the capital of the U.S. major financial institutions. The fraud and everything else was that pervasive. And if you go further into his testimony that day and everything else, he talks about how it'll take decades before it cleans up. Now, here's the point I'd like to make about the state of Connecticut. No one wins as a pro se in a pro se foreclosure. Pretty much anyone who's in foreclosure doesn't win. Now, because I'm a math guy, there's a problem.
Well, wait, can I stop you just for a second? Why just emphasize that point to the point of pro se or being in foreclosure in general, even with an attorney? Why being pro se?
Sui juris, a private individual representing themselves before the court. Even when you get an attorney, you don't win your foreclosure. Okay? Which is important to know, because you're going to spend a lot of money with an attorney, and in the end, the best you might get is some sort of workout at best. But they also want to trap you with stuff with the workout. But let's not go there. I want to keep with this simple part.
Okay.
There's so much fraud that it would take decades, everything, systematic problems in the trillions. Yet, now, please remember this, and everybody's heard this from the U.S. Supreme Court, fraud vitiates everything. We've all heard that line because of everything with the election. Fraud vitiates everything. That means if a document has one thing on it that's fraudulent, the whole document's fraudulent. It's got to be thrown out. It's no good. And everything connected to it is no good. Now, how is it that all the foreclosures in the state of Connecticut, we have perfect documents? They're all perfect. We represent fraud to the court, and the court goes, oh, no, nothing, that's fine. Let's look beyond that and go.
Right. It's just ignored. Ignored.
Yeah. Willfully disregarded and ignored. Now, what I would like to do is turn to document 458.
Okay.
Okay, 458.
I'm sorry.
This
Hang
is
on. I'm sorry.
This is from a mortgage-backed expert, attorney Kathleen Cully's view and opinion. Kathleen Cully, a Yale-educated lawyer who is an expert in the sale of mortgage loans between financial institutions, having practiced in the area over 20 years in senior positions at Citigroup, Fitch Ratings Inc., and Financials Guarantors and ACA Financial Guarantee Corporation, CIFG, in RMBS securitizations. The ownership of the borrower's promissory note, mortgage, and mortgage loan were to be sold and transferred according to Article 9 of the Uniform Commercial Code. In various opinions, my distinguished colleague has authored, and she opines that for over 15 years, Article 9 has provided the exclusive way to establish ownership of the mortgage note, mortgage, or mortgage loan, because Article 9 was amended effective July 1, 2001 to include sales as well as pledges of promissory notes, payments, intangibles. She writes one such opinion in Junk Daniel, Anyway, I'll go down to read what she said in this particular case. As explained by the Uniform Law Commission itself, certain kinds of transactions that did not come under Article 9 before now come under Article 9. These are some of the kinds of collateral that are included in revised Article 9 that are not original Article 9. Sales of payment and intangibles and promissory notes. She then goes on to say, let's see down here, sale is enforceable against, I don't want to get too far ahead.
It's on screen here, right where you're at.
I want to stop here because I don't want to get too technical. I understand what this means and I don't want to lose the audience. Okay, what we're talking about in terms of Article 9. Article 9 is UCC code, Uniform Commercial Code 9. Uniform Commercial Code, the Uniform Commercial Code, so everybody understands, is the code that was passed, I think it was in the 50s. Now I forgot. I should know it, but my head's only so big. Uniform Commercial Code was passed to enable interstate trade with no problems. So every state approved the Uniform Commercial Code, and every state has its own statutes that match that of the Uniform Commercial Code. In the state of Connecticut, I think the prefix is 9. Like they do 9-9 would be Article 9, right? In Texas, maybe it's, I don't know, something different, where then it would be -9 and it's the same uniform code. So every state has it within their state statutes. Okay, now what? I want you to remember Article 9 because it's significant about the stuff that I'm going to show you. If you can go to document 460. No, you don't need to go there. Document 460 is nothing more than the actual Article 9, and you can read what's involved there, which I'll show you, but do remember that if you want to look it up later. What I would like you to go to is there is one more statement I want to read of hers that to put this in perspective. Okay. Section 9, the section that's most significant is section 9 is 203. Section 9-203, these are her words, of course, supersedes and revokes any inconsistent prior common or even statutory law. Any statutory law. Consequently, no transfer or negotiation of a promissory note, whether or not the note is negotiable, can transfer ownership of a promissory note unless it complies with Article 9-4. Okay? And so 9-203B is the most significant thing. Okay? And it's important to remember because that goes to chain of title, and the term in terms of chain of title, the legal term is called perfection. There cannot be any errors. Now, once again, remember Article 9 because it's significant with Connecticut. Connecticut in their little corrupt little game here goes with Article 3, which no longer holds weight, but they like to stay in Article 3. And then they use a little con that they play. Okay. If we could go to, let's see, if we could go to, let me look it up here myself. It is 469. And this one's significant. Exhibit 469 is a New York Times article by a Pulitzer Prize winning journalist. And what did he get? I think he got the Pulitzer Prize for all the stuff on Oxycontin.
Wow.
I think he was the one that broke the story on Oxycontin and all that stuff. But we'll see here. Barry Meyer, okay? He wrote this in 2010. Foreclosures profit some equity firms, okay? So I want to read this because it has lots of names of Connecticut and everything else, and you're also going to get a sense of the interstate stuff. And I'm going to show you more stuff involving this as we go through this.
There you go. Dated October 20th, 2010.
Yep.
Barry Meyer.
Yep, Barry Meyer. So we don't have to read the whole thing, but there's an entity called Promise Solutions, okay? And on that first page, I'll just start here. With a surge in lawsuits against law firms specializing in foreclosures, a case in Mississippi is casting light on another aspect of the mortgage mess: the connection between Wall Street private equity firms and those law firms often known as foreclosure mills. The lawsuit on behalf of homeowners claimed that Great Hill Partners, a private equity firm, has benefited from the lawsuit calls an illegal fee splitting arrangement between Promise Solutions and several of the busiest foreclosure law firms it controls. Great Hills is the biggest stakeholder in Promise, a company that acts as a middleman between mortgage servicers and law firms. They handle all the documents and everything, okay? So they're handling all the documents. Now, highlighted there, you'll see, but a review of public filings, company news releases, and other public statements shows that several private equity firms or entities they control have stakes in the business operations of some of the busiest foreclosure law firms in New York, California, Connecticut, Florida, Georgia, and Texas. Okay? We go down a couple other pages. I just want to get on to the names. You'll see, let's see, on page 3, you'll see underlined and highlighted. Soon afterward, the fund bought similar operations from one of the Connecticut's biggest foreclosure law firms, Hunt, Liebert, Jacobson of Hartford.
Wow.
Okay? Which they then bought. This is McCullough Raymer, who bought Hunt, Liebert, Jacobson of Hartford. So that's getting to McCullough, Liebert, Pierce, blah, blah, blah. Now, let me go down a little bit before. Okay, if you go down to page 5, the roots of Promise, based in Atlanta, trace back to 2006 when the company acquired the back office operations of McCullough Raymer, one of the country's biggest foreclosure mills. So Promise bought the
what a kind and gentle euphemism.
Bought the back office office operations of McCullough Raymer. So McCullough Raymer Liebert Pierce, which is the largest foreclosure mill in the state of Connecticut, which is also one of the largest in all these other states. Okay? You getting it? Right? And all they did, now this is important, is they moved their back office operations, in other words, collecting all the documents and stuff and working all the documents, to Promise. What I would like to leave it as the name Promise, right? Okay. Mm-hmm. Promise. Okay. On page 6, you'll see McCullough Raymer Pierce LLC and Hunt Liebert Jacobson PC announced the combining of the firms to form McCullough Raymer Liebert Pierce, February 1, 2017.
Oh, okay. This is it here.
Yep. Right behind that, you'll see a little bio on Barry Meyer, so you know that this is a serious guy.
Yep.
And so he's
very thorough, very well sourced
he does his homework. Okay, now we're getting into Andy work. So I pulled files on. I pulled financials on Promise, okay? And I read through the 246 pages of their S1, okay? And I'm just going to highlight some of the pages, okay? You see the first page, doesn't matter. Let's see.
Okay.
If you go down to page 9,
Sure.
if you go down to where it's highlighted there, you can see where it says we begin operating as a standalone business in February 2006 when we acquired the mortgage default resolution processing operations of McCullough Raymer. So they're the seed that spawned Promise Solutions, a real estate law firm based in Atlanta, Georgia. So McCullough Raymer is Atlanta, Georgia, big boy in Atlanta, Georgia. Okay. Now, let's keep going because
our pages aren't lining up. You're saying page 9, but I'm starting on, according to the paperwork itself, page 120.
Oh no, I'm not. No, don't go by the paperwork. Go by the pages
where we're at in the presentation. I see.
Yeah.
Okay. So business overview.
Yeah, because these are pulled out from 246 pages.
Gotcha.
All right. So if we go down to page 11. Page 11. Okay. Daniel D. Phelan, Vice Chairman and Director. Okay. You see on page 11? Remember that guy. Let's go down to page 12. Page 12. Okay. You ready for Daniel Phelan? Daniel D. Phelan has served as our vice chairman since May 2010 and a member of our board of directors since our inception. From our inception until May 2010, Mr. Phelan served as our chairman. Mr. Phelan served as our chief executive officer from February 2006 to January 2008. Prior to that, from 1988 to 2006, remember there was somebody that sold some stuff, Mr. Phelan was an attorney at McCullough Raymer, serving as managing partner and providing senior oversight to McCullough Raymer's processing operations. Prior to joining McCullough Raymer, Mr. Phelan was a partner at Kurtzman & Langbein, blah, 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 blah. So now Mr. Phelan, Mr. McCullough Raymer, and everything else, dirty dealer. If you go to right there, page 12, and you go to 13, you'll still read experience in real estate transaction processing, leadership of complex organizations and people management, legal, regulatory, and governmental affairs that strengthen the board's collective qualification, skills, and experience. That's another way of saying racketeering. He's an expert in racketeering.
Lots of kind, gentle euphemisms here.
Yes. So now we go down on 13. Still on 13, if you look at the highlighted part. Mr. Phelan was nominated to our board by our stockholders who were affiliated with McCullough Raymer at the time of the Great Hill acquisition. It's like the most incestuous thing you've ever seen. For somebody that's a Wall Street guy. Now, if we go down to page 15, just to see how incestuous it is, Mr. Phelan has 3 million plus shares of this enterprise.
As seen there in the first of the right-hand column.
Yeah. And if you go down a little bit more, because you got to learn how to really look at this stuff, he also has got options on another 1.8 million. So this guy's not hurting here. This is good stuff. Now, if we go down to page 17, here we go, McCullough Raymer agreements. Certain of our stockholders who were affiliated with McCullough Raymer at the time of the Great Hill acquisition, the MR stockholders and option holders are partners and equity holders and former partners and managers and employees of McCullough Raymer, including our vice chairman, Mr. Phelan. Okay? So he's still a partner in everything in McCullough Raymer. Now here's the best part. Go down to the next piece. It says the McCullough Raymer acquisition agreement. On February 24, 2006, we entered into a contribution agreement, acquisition with McCullough Raymer and certain of its affiliates, into which we acquired certain non-legal bankruptcy, foreclosure, and REO business processing assets from McCullough Raymer and such affiliates for approximately $137 million in cash and issuance of shares, blah, blah, blah. So that was the swap, cash stock swap that they did to get those agreements going back and forth. Now, what we have here is you have a large national, basically foreclosure processing plant here, okay, with the documents. Yet at the same time, you have one of the
Foreclosure mill.
largest
It's a mill.
You have the largest foreclosure law firms who basically call up and say, do this, do that, say this, do that, and everything else. And as you go to page 19, you'll see further. There's more stuff with Mr. Phelan and his connections there, more about his money. This is one of my favorites. If you go to page 20, this cracked me up because it's like these guys are literally laughing at us. Ready? 5-star lease and services. Our vice chairman, Mr. Phelan, also owns a 50% interest in 5-Star Shredding Inc.
What?
He owns, our vice chairman, Mr. Phelan, owns a 50% interest in 5-Star Shredding Inc., a Georgia company that provides record storage and management services. These are the guys that shred all the documents when they get in trouble. We're a party to an agreement to sublet a portion of our Alpharetta, Georgia facility to 5-Star. So they literally have 5-Star Shredding located in the same facility as the documents, so they can shred them whenever there's a problem and clean stuff up and get rid of it as fast as you can when they close on something. I mean, it's unbelievable.
I think the LAPD uses the same source.
It's unreal. Oh my gosh. Anyway, let's go to document 872. So now we go way down the docket.
Okie dokie. Let's see here. 872. Getting to it. Oh, yeah. We're almost rock bottom down here.
Yeah. 872. These are some exhibits that I put in for actually this particular thing.
Alrighty.
Okay. Now we're going to get into Connecticut and sort of its racketeering and actually the interstate racketeering that goes on and the game and the subtle twists and basically the script and playbook and everything else.
The winking, the nodding, the gin behind closed doors.
Now, I put 872 before a couple.
The backdating on Sundays.
Yeah. Okay. In 2007, and we'll get to her next, but in 2007, Chief Justice Rogers, because they were doing so many foreclosures and stuff, set up a thing called here in Connecticut called the bench, as in judicial bench, bar, as in the registry,
British accredited registry.
Yes, for the lawyers, the bench bar committee. And the whole bit was to speed up the whole foreclosure process. And we'll get into all that script a little bit later here. There were several people that were selected for that bench bar committee. One of them being attorney Jeff Milne, M-I-L-N-E, of McCullough, Raymer, Lieber, Pierce, LLC.
So real quick, because I think it's a important detail. These are not elected positions. These are appointed individuals, kind of like unaccountable czars, if you will, if we want to kind of, meddle with the words a little bit here. These are unelected officials appointed by corrupt officials, essentially, right? Okay,
yes.
Thank you.
Yes. So what you see here is that actual announcement, and you can see all the different people that are named on this committee. If you go down, I highlight a couple that are important. You'll see them in bold. A gentleman named Attorney Dennis Karen. Remember that? You'll see also Adam Bendett. He's of Bendett McHugh, which is the second largest foreclosure mill here in the state of Connecticut.
McHugh is actually a big family in Connecticut. They actually, I'm not saying I know for certain that there is a relation here, but there is a McHugh mortgage and large standing businesses throughout the state of Connecticut owned by a Mr. I think it's Bill McHugh. I don't know if there's any sort of relation to these McHughs, but it would be interesting to see if there is.
I don't know. If you also will notice, you'll also see that attorney Richard Liebert of Hunt Liebert or Liebert of
Geoffrey Kent Milne.
and then attorney Jeffrey
Geoff-
Milne. Okay.
Geoffrey.
Yep. Milne. Now, what's significant about him? Who is attorney Milne and what is he all about? He's a managing partner of Connecticut Litigation. This is his bio that's up on the internet.
I see we have note of Rhonda Hebert. She is what's known as the head of external affairs. She's like the head head clerk, if you will, chief of external affairs. I've had a plethora of correspondence with her, and I just like to let my audience know that I am going to publicly disclose the great disappointment that correspondence has been. This is a woman, if you're a member of press, if you're an independent journalist here in the state of Connecticut and you would like to get your cameras, your microphones, your eyes and ears inside of the judicial system here in the state of Connecticut, the first line of defense that our weaponized judicial will use to obstruct that level of access is it starts right here in Rhonda Hebert's office. And I've had a great many of conversations with her that I think will be quite revealing, telling of our judicial system here. And I'm sorry to detract from our main theme here, but that's an important name to know. If you're going to be conducting official business as an official entity here in the state of Connecticut, conducting official press activities, you're going to run into her. And while she is on a personal level very pleasant and very kind and cordial, on a professional level and in her official capacity, her hands are obviously tied. She could agree with you until she's blue in the face and understand what it is that you're trying to do, and she will not be able to help you facilitate executing that. Anyway, I digress.
So Jeff Milne, I believe is a key part and developer and operator of this foreclosure racketeering system operating in Connecticut and elsewhere, this scheme. Okay. Now, why do I say that? He and Karen, if you look underneath in his bio, you'll see a thing that says Connecticut Foreclosures, an attorney's manual of practice and procedure, 7th edition. This is the gospel of what the lawyers use to counter. It literally is like a script as to what to do and what to say up against different issues that are raised.
The playbook.
I'm going to before the night's over, I'll touch on a couple of pieces from it. So people understand, but we'll go back to that. Okay, so attorney Karen and Milne literally have written. I think the book in total is like 1,000 pages or something. It costs like $1,500 to buy, which the attorneys buy, of course, the law firms, and then go from there. I wrote here in this stuff. I described some of this stuff. Attorney Jeff Milne. I'm on page 3. Attorney Jeff Milne holds himself as a foreclosure legal expert. He uses his mantle to obfuscate the requirement of a perfection of chain of title regarding property rights. Whenever in court or addressing the subject of foreclosure, Attorney Milne directs attention to Connecticut General Statute 4917 as an assignment and standing. The manual or script for railroad racketeering system is the Connecticut Foreclosures and Attorneys Manual of Practice Procedure, blah, blah, blah. And then I highlight some stuff. Section 11B, standing issues. Note holder as plaintiff, Connecticut General Statutes 4917 has been a part of the state's statutory foreclosure repertoire for many decades, but was seldom needed before the surge in secondary mortgage activity that began in the 90s. The title of the statute tells it all. Foreclosure by owner of debt without legal title. The statute permits a mortgage foreclosure to be prosecuted by the person entitled to receive the money secured by blah, 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 blah. You can all read that. Since Connecticut follows the theory of It goes on. This is a deflection of standing and subject matter jurisdiction. It is obvious upon reading Attorney Mills' manual, the cozy relationship the bench bar committee has created. Conveniently, Connecticut General Statute 4910 is willfully ignored and disregarded by all complicit participants in the railroad racketeering system established by the 2007 bench bar committee. And then I go into what is Connecticut General Statute 4910.
And if you're just joining us, this is what's known as Andy work.
Yes. Connecticut General Statute 4910. See, 4917 is a BS little thing that says like any assignment's good. Okay. But the truth is an assignment, you have to be able, if challenged, you have to prove the transaction. If you challenge it at all, they have to give you the actual transaction. Now, in 2008 and 2009, what the federal government did is they even made it a federal requirement that any assignment, there is to be what's known as a Section 404 notice sent. And there's a law that states exactly what has to be in that notice. Now, state of Connecticut, because they want to hide all that new stuff, this is what they did. And it's important to understand so you can see how dirty all this crap is. Okay. This is so messy the way they wrote this. And I'm that's why I put it down. Okay. Connecticut General Statute 4910, assignment of mortgage debt, form of instrument requirements, sufficient notice of assignment, allocation of recording fees paid by a nominee of a mortgage, operation of executed assignment is the law that makes an assignment valid for standing. Parts F and G highlighted below define what is required for a valid assignment. Okay. Now, Part F says by giving notice of the assignment pursuant to 12 USC Section 2605, Section 6 of the Federal Real Estate Settlement Procedures Act of 1974. And get this, and the regulations promulgated pursuant to said section as from time to time amended. Okay, they buried what is the Section 4. That's why I follow up and say what the Section 404, the issue that came out of the Helping Families Save the Homes Act of 2009.
Undermining, railroading, subverting. This is willful, conscious.
Yes.
This is deliberate. This is a crime, ladies and gentlemen.
Right here. Because what they should be saying right here is a federally required letter pursuant to Section 404 of the Helping Families Savings Homes Act of 2009. Not this Real Estate Settlement Procedures Act of 1974, and then all the follow-on amendments and stuff. Give me a break. That's pure. For me to, quite honestly, for me to find this, I was like, how the hell did they do this? And by the way, if you read 4910 in its entirety, you're going to go, oh my God, it's one of these things. If not A, then C, then D is E, but F is 3. You know, you're like.
Right. I encourage everybody watching to please do your homework, do your research, learn how to protect yourselves.
This is all here. Now, if we go to page 4, you'll see I go into the Section 404 letter. And you'll see.
Help direct me here.
Page 4 on the.
It should be like the
4 out of 10. There's 10 pages in this exhibit.
Okay. All right. Hang on. Let me count to where we were at. Biography. Let's see. We were just on 4910. So how many pages beyond this?
Okay. If you go from the top, 1, 2, 3, 4.
1, 2, 3, 4. Section 404, federally required transaction letter.
There's the Section 404 letter and notice. It's a requirement control. It's a OCC mortgage requirement, all these things. Okay. So that's the bank guys, the controlling things. Also, you have to have a proof of transaction. Okay. That comes back to 4910. There has to be proof, a valid proof of transaction, thus giving you the assignment. You can't just write it on the back of an envelope. Then what I've given you here is the actual section of 4917. And as you will see, it says, unless, in highlighted there, I say, unless the presumption is rebutted. Okay, so if you challenge it in any way, they need to prove it. Then I go and give you what is 4910. You can see everything that's there in terms of 4910. And when you read the entirety of 4910, you'll know what I mean by going A, B, C, F, G. Like, what the hell?
Anything less invalidates it all.
This purposely bails, Anyway, I share all this. There's more comments in here that go into stuff, and you'll get the connection with Justice Rogers. I want to go because I don't want to keep killing people with this stuff. I want to go to 873 now.
Okay. Just a moment.
873 is Chief Justice Rogers. And Chief Justice Rogers retired in 2018. Chief Justice Rogers of the Supreme Court, Chase Rogers, establishes the Bench Bar Foreclosure Committee in October 2007, empowering racketeering and railroading with no restraints. Rogue power. This woman basically, truly unbelievable to even hear what she says. And what I'd like to do is a woman did a piece to basically say that Chief Rogers should not be reappointed to the bench. And she gives a breakdown of everything. She gives a breakdown of how the corrupt foreclosure courts operate as a Connecticut corrupt organization and racketeering enterprise. The Hobbs Act, the Administrative Procedure Act, the structure was created and developed by Chief Justice Rogers in 2018 and continues today with most of the same complicit participants. Now, she didn't say that was me, but this is the following is Vivian Winslow's Doomer's statement and links. And it's very worthwhile for you guys to go look through this because you'll see the appointment thing. You'll see all her stuff. Okay. And it is amazing. All right.
There it is. External Affairs. Rhonda Hebert.
Oh, yeah.
It's going to be the one you're going to want to deal with.
This ties into Blumenthal. Now, let's remember Blumenthal. Blumenthal was the attorney general that signed off on all the stuff for the 08, 09.
Lying Denang Dick Blumenthal.
Yes, lying. And here's a guy who lied about his service. And literally everybody was like, he's dead. I mean, because
lying Denang Dick Blumenthal.
But the next thing you know, he is like the lead senator with all the banking stuff and everything else.
It makes no logical sense at all.
Okay.
I don't understand.
Okay, stop. This is an important point that I want to make to everybody. I am not political. I am good versus evil. Okay. There are both sides, both parties. Everybody's involved here.
And to that point, here at Tyrant Slayer Studios, we are not political.
Okay.
We don't go after one side of. We don't target independents, libertarians, Democrats, Republicans, any walk of life. We focus our efforts upon exposing crimes perpetrated by our local, state, and federal government. Crimes perpetrated against the people, right? And we expose that with the hopes of creating transparency and accountability. And of course, when appropriate on, let's say, in this case, Andy's behalf, liability. Someone needs to be held accountable and liable for what's happening to this man and his family. How do you think this man's Christmas went?
Wait. I got so much to go through here. People got to know this stuff.
I digress.
Okay. Let's go to page 7.
Okay.
7 of 28. You should be able to see up in the side somewhere that.
What's it start with? Give me a context.
It says the first page, the top, it does based on the rate of how fast. Then it says in the middle, YouTube removed it. Read transcript below.
Okay.
It's been highlighted.
Oh, there's our lying Denang Dick Blumenthal for the folks wondering what he may look like. Perhaps I missed it. Perhaps I'm too far. It's
Keep
page
going
7.
down. Go below
Okay,
the
okay.
Blumenthal.
Okay.
It says YouTube removed it. Read transcript below.
Got it.
Okay. I knew that they were going to remove this particular video from YouTube when I started pushing stuff around about it. This woman, and I was not the one that got this. It was Vivian, it's her hard work. But what I did was I got the video and I had it transcribed. So the whole 9 minutes of Justice Rogers rubber stamping rules and nominations without discussion in 2012, which was a public meeting that anybody can go to. And I just want to highlight some of her comments. Okay, underlined, you can see the number one challenge we face is the number of self-represented parties continues to grow. That's a challenge. Okay. The fact is the explosion of self-represented parties is no longer a trend. What we have is a national phenomenon that's not going away and requires a proactive response by the branch. This is a national problem, not a Connecticut problem. So in other words, you representing yourself, you're a problem.
Yeah, that's insane. I mean, we hear our federal representatives.
No, stop. That is the Chief Justice in the Constitution state. Okay? The Chief Justice in 2012 saying anyone that wants to represent themselves in our courts, that's a major problem.
We're treated like a threat instead of a participating member of our society who's experiencing an injustice. We're losing our voice. We're losing our right to justice. We're a right to due process.
Listen to what she says here. This is a national problem, not a Connecticut problem. I want to focus on it. Again, just a few of the other states. This is sort of across the board from California to Connecticut. But in New York, 1.8 million litigants appeared in state courts without an attorney last year.
Translation, the people are becoming educated, and it's a problem.
And then it said, then you go down, and she says, the blunt answer is the judicial system is, now this is important. The blunt answer is the judicial system is based on a model where lawyers advocate for their clients.
For market, for revenue, for profit.
Yes. I now underline, I know there are some who question the wisdom or the propriety of the branch's efforts to assist self-represented parties by providing services to them. And I believe, though, that to ignore them is to ignore our primary responsibility as judges, which is to make sure that justice is actually being done. I'm like, I can't believe she just said that. That's fantastic. Then you go down. Leads me to the second development that has changed the way that we have to do business. So she's now saying we've got to change the way we do business.
We're not doing the order of justice.
Yeah.
We're doing business.
It's business.
And as you know, business is cutthroat. Guess whose throat they want to cut?
Now we underline. We also know that lawyers are struggling to maintain their clientele, while at the same time we're confronting the influx of people who in the past would have hired lawyers.
Well, who could afford to pay a guy $50,000 to do the right thing?
But obviously, attorneys are greatly affected by this development, and they need to be a part of the solution. So you guys work with us to shut out these pro se or any individual. We're gonna tilt the scales of justice. Okay. The irony of all this is the LegalZoom.com has, according to Bloomberg Business Week, filed an IPO for the amount of $120 million earlier this month. Frankly, this is unbelievable. Chief Justice, I would much rather see that money going to the legal profession so that people are represented in our courtrooms.
Oh, my God.
It's all about the money. Then it goes down, next paragraph. I'm going to focus on the rest of my time is that we must re-engineer our court system. Then she says, we need to take a serious second look at how a court case should be processed. In other words, the outcome has to be the same, but we may need to revamp the means by which we get there.
So everything has been predetermined in the wink and nod. Let's have some gin.
Yes.
And get a little cocked up here behind the walls. And we'll figure out what we're going to do with Mr. Riley.
Here is the most telling statement, I think, of the whole thing, which really drives me nuts. Okay? Because this is how our state constitution is written and how law should happen in the Constitution state. This is her words, underlined. Our entire civil system is currently geared towards culminating in a jury trial. It's actually a trial by jury, which is different than a jury trial. That's important to know. Which actually occurs only in a very small percentage of cases. That's because these guys don't allow it.
That's right.
They do not allow it.
That's exactly the problem that I'm facing, and that the Constitution State, if you don't know the Constitution State, head on over to his YouTube channel. He's got a plethora of cases he can open for legal recourse and accountability here in the state of Connecticut. Every public official he makes contact with violates his rights, and he's been assaulted. His press equipment has been damaged. His rights have been violated to the umpteenth degree.
So now if we go down further, you'll see her say, work. I'm currently forming an advisory group composed of judges and staff. So we're going to have judges and staff get together and really make these decisions. Then we go down further. Use of video conferencing and advances in our computer technology are moving us one step further towards creating the virtual courtroom where the parties and the judge can be in different locations when necessary or appropriate. I highlight that because all these remote hearings, nobody has jurisdiction. There is no law that allows it. There's no security.
Well, what happens is they send the clerks to you via email or via postal USPS correspondence, and they get you. They force you. They basically threaten you with a failure to appear if you don't waive your right and say, yes, I'll attend that remote. They send you that little verification notice. Are you going to attend? Yes, no. And if you say no, they're going to give you a failure to appear.
No, we can get.
Well, that's what happened with me in the family court.
I understand. I'm telling you, everyone should say to a remote hearing, all remote hearings, they do not have the jurisdiction. There is no statute that gives them a jurisdiction.
It's been widely reported, even on the likes of corporate media, that it is absolutely unconstitutional.
Yes.
But I think the leverage that they have is when you agree and respond to that email under the duress of the clerks, you waive your rights.
Stop. The rule is this, and it's in the Administrative Procedures Act of 1946, the law. The law states that if both parties agree to a particular jurisdiction, and the court says it's okay, then that can happen. Proof of this, when there first came people needing to do a conference call, both parties had to agree to the secure lines of the conference call. This is in federal court. And then it can be accepted as part of the jurisdiction.
That's what I think is happening.
If one party says no, then the case only can occur in the courtroom where the judge has jurisdiction.
That is absolutely correct. But under the circumstance I experienced firsthand, the clerk won't allow you to say no without punishing you.
Listen, Tim, no offense. I have 128 remote hearings that I was not present at, 128 of them that Judge Spader ruled against me. Okay? So I do know this. All right? It's just like...
Well, yes, I know. You're 100% correct, but I'm just saying the clerk is going to be the one that tries to get you to waive your rights away and agree to that set of circumstances.
Well, let's stay with this corruption here. So in conclusion, it's fair to say that the influx of self-represented parties and enhancements to technology have combined to have a huge impact on the way we have to do business, not justice, business as a branch. Everything's about business.
Yeah, it's disgusting.
And then we say here, of course, we all know that 50 years from now, a whole new generation, thank God, will be dealing laughter with a new set of issues that we could not possibly have anticipated. Much like those before us, we could not have anticipated that we now face. We know this isn't going to be easy. However, I'm confident with your help and input per usual, we will do the best we can to ensure that justice continues to be served in the state courthouses in Connecticut. So thank you for the opportunity to address you today, and I will turn the podium over to Judge Quinn again. Thank you. So basically, she right here has basically said that the pro se or the individual does not have the same standing in the courtroom, that we need to do everything we can to basically eliminate even the thought of that. So,
right. We have to pay someone else and be 100% dependent financially, mentally, emotionally, spiritually, socially, culturally, in someone else who's going to charge us $800 an hour to essentially articulate what we can ourselves. Granted, we are inclined enough to know the rules on how to properly do that. It's insane. You can't get justice unless you pay and go bankrupt paying for justice. That's insane. That's not what the founders intended.
Okay, I would like to go to page 27 because this is one of the most key things of all. Page 27. So that's one up from the bottom.
This one here. The court, with all its judges, procedures, and protocols,
Yes.
Okay.
That has to do with my case or whatever. So
yep,
here we go. In the middle, it says here. You'll see it says the Connecticut Chief Justice of the Supreme Court, Chase Rogers, that's here we are with her, demonstrated bias for the bank's mortgage servicers in the key case, and this is a key case that they lean on, J.E. Robert Company, Inc. versus Signature Properties, LLC. Okay, and it says here in the ruling, therefore, even assuming 4917, there's that 4917, applies in a case in which the ownership of the note and the mortgage rests in the same party, blah, blah, blah. Now let's go to where it's highlighted. Indeed, limiting such actions when such an intent clearly is expressed would inhibit the commercial pooling of mortgages, which is a common financial tool for lending institutions and would thereby discourage such institutions from underwriting loans in the state. So her reason for ruling for 4917 is it would hinder the banks being able to pool mortgages. Okay?
That's incredible.
That has nothing to do with justice. There were mortgages before there were mortgage-backed securities and pooling of mortgages. And I would also even add that if the state of Connecticut actually stuck with common law and actually looked at 4910 and monitored the custody of the title and the perfection of the chain of title, the state of Connecticut would have the best property values of any state within the country because it would never have entered into mortgage-backed securities and all these shenanigans.
Well, there's no money in that honest business.
The reason she's ruling this way, keep in mind, when this all's going down and stuff, this is the afterside of 0809. She's basically given the okie dokie to run the printing press with 4917. So Chase Rogers, bench bar committee lady, okay, and everything else is giving a rubber stamp to 4917 with this Supreme Court ruling because she's the big boss. Observing, and even in this ruling, this is what really gets good. This is her stuff, right? Observing that in more recent years, mortgage structuring and issuance of private mortgage-based securities has become much more complex and widespread. Please see D. Karen and G. Milne of Connecticut Foreclosures describing tenfold increase in mortgage-backed securities. So you see this circular little coven or whatever you call that, where it's like, oh, we'll go back. You say this and I'll say it's true. And then you say this and I'll say you're true, blah, 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 blah. So we have Jeffrey Mill giving what the judge needs to say. So then I wrote here, just so everybody has it, the bank bias Supreme Court is justifying their ruling because indeed limiting such actions when such an intent clearly is expressed would inhibit the commercial pooling of mortgages, which is a common financial tool for lending institutions, and would thereby discourage such institutions from underwriting loans in the state. To put it simply, the court is here to keep the foreclosure money machine going. To the Chief Justice of the Supreme Court, Judge Rogers, retired. Classic mortgages financed the housing market in the state of Connecticut long before mortgage-backed securities with less volatility and more secure property values. There are alternative financial structures that have more positive benefits to the state and homeowners. The courts, the banks, and the mortgage servicers, the foreclosure lawyers, through complicity and collusion, are harvesting properties through constructive fraud. The administrative duty of law has been pushed aside for money, not justice, as we can hear from all the business we got to do. The rationale and the agreement for doing this is the coffers of the financial institutions need to be replenished. The banks, in collusion with the court and attorneys, have set up a system to extort money from the public by using the power of the foreclosure court. This becomes quite obvious in my case, just when you look at the appraisals of my house, how absurd it is that my note has been sold to 4 different buyers, and all the court record demonstrates the corrupt actions of all. Right? I don't want to get into my case. Now, this is important. No lawyer in the state of Connecticut would take this case, meaning mine, because they know it would ruin their career as a lawyer. The legal community is a club, or as the judges keep saying, a brotherhood. The Bench Bar Foreclosure Committee established October 23, 2007. Okay, then the last piece I want to get to is, let's see, which is 874.
Roger.
So, and this is to take it away just from Andy. This is a transcript of a video that you can find, and it's of Joe Visconti, who was running for governor. And he made comments before the legislators or something like that. I can't remember.
He's been around a long time. He's a powerful presence here in the state of Connecticut, for those of you who don't know.
Anyway, I just want to read it. I want to read it to you because it takes no time at all. Okay? This is his statement. Speaker 1, Joe Visconti. Speaker 1, good morning, Chief and Chief Justices. So he's before all the justices. I'd like to address the Rules Committee as it relates to foreclosure, to the foreclosure docket. I'm Joe Visconti. I'm a candidate for governor of the state of Connecticut. I come before you today out of great concern that our judicial branch of government is broken. It's not impartial. In fact, it's biased. Because of some of the changes implemented by Chief Justice Chase Rogers, foreclosure mill law firms are involved in making the rules and foreclosure processes, which can directly benefit their gross profit. Oh, I wonder where that came. How did I know that too? Holy cow. This was done by the creation of Foreclosure Benchmark Committee. That's the Bench Bar Committee, okay? And allowing the foreclosure lawyers privileges never given to the side of adversarial legal process. Justice Rogers has created a class of legal robber barons whose primary interest, as with all businesses, is self-enrichment and not necessarily justice. These are supposed to be the rules the judges are supposed to follow and honor. Instead, they are long forgotten in the rush to justice is created not by the foreclosure defendant, by inherently flawed banking and lending system. This is further complicated by the foreclosure mills such as Hunt, Liebert, and Jacobson, which is now McCullough-Raymond, the largest in the state by far, amongst others, having a seat at the table. Seriously. Let's bring the fox into the henhouse. This has created a new phrase employed by thousands who have gone through the foreclosure process and lost their home. The phrase is called mortgage laundering. the taking of a person's home by illegal and unethical means, and by selling or transferring the title over and over again in the mortgage portfolio, discouraged of tracing of the act and to avoid anyone's ability to follow the ownership of the possible recovery.
What a courageous statement. Applause and accolades to Joe Visconti.
Yes.
I haven't said anything good about the man in 3 or 4 years, and this is the first I'm learning that he's been on the right page for a
Rule
long time.
2.4.4, external just influence on judicial conduct or judgment. An independent judiciary requires its judges decide cases according to the law and fact without to regard whether particular laws or litigants are popular or unpopular with the public, the media, the government officials, or the judges' friends or families. The integrity of the judicial decision-making is determined as based on whole or in part by inappropriate outside influences, such as access afforded by the foreclosure mill lawyers. The Hunt Lieber Jacobson law firm and managing partner Richard Lieber, amongst others, has undue influence over the judicial division by virtue of their involvement in the judicial bench bar foreclosure committee. They were appointed by Supreme Court Justice Jace Rogers. And this has opened the judiciary to direct access and influence by the very people they see every Monday during the foreclosure short calendar. A massive conflict of interest. An independent, fair, and impartial judiciary is indispensable to our system of justice. The United States legal system is based on the principle of an independent, impartial, competent judiciary, composed of men and women of integrity who will interpret and apply the law that governs our society. Thus, the judiciary plays a central role in preserving the principles of justice and the rule of law. Inherently, all the rules contained in this code are present. The judges individually and collectively must respect and honor the judicial office as a public trust and strive to maintain and enhance confidence in the legal system. Judges should maintain the dignity of the judicial office at all times, above both impropriety, in the appearance of impropriety in their professional and personal lives. They should aspire at all times to conduct and ensure the greatest possible public confidence in their independence, impartiality, integrity, and competence. This is not the case in Connecticut because of the inclusion of the foreclosure mill lawyers in the rulemaking process. Holy shit! The Code of Judicial Conduct established standards of ethical conduct of judges, matters affecting the performance of their judicial duties and fair and efficient operations of the courts and other tribunals on which they serve. Although it is not intended as an exhaustive guide for the conduct of judges, who must be guided in their professional and personal lives by general ethical standards as well as by the law, which includes this code. It is intended to assist judges in maintaining the highest standards of professional and personal conduct as it affects your judicial work, and it has failed Connecticut because of Justice Chase Rogers and Governor Malloy, who allows her to sit in the highest position in the Connecticut Judicial Division. I call on Governor Malloy to stand up for the people of the state of Connecticut and stop the favoritism and protect our citizens from judges who are complicit in the largest land grab in the history of this nation by turning the other way and granting motions without basis or evidence. Thank you. So it's not just Andy coming up with this. It's a guy who was running for governor in 2014. Now, I want to go back on a couple of things real quick. Promise Solutions, which they purposely allowed to go bankrupt, and then they moved it into another place, which is what criminals do, just like the mob keeps burning down and restarting a restaurant, right? They're the ones that've been doing all the fraud. We're doing all the fraudulent paperwork and everything and moving it around. The whole thing is a system of nothing but fraud and just pure bullshit. Now, as I said to you earlier, I want to talk about and this is the last bit, and I'll show you, and we'll stop from there. I was blessed with getting about 170 pages of that foreclosure book. And I read from the chapter 1, just page 1 of chapter 1. The title of the statute tells it all. Foreclosure by the owner of debt without legal title. And then in there, this is from Jeff Milne and Karen. Since Connecticut follows title theory of mortgages, heightened importance is placed on maintaining. Now, this is important. Here's the con. Heightened importance is placed on maintaining an unbroken chain of assignments of a mortgage. not unbroken chain of title. No. It's chain of title. Perfection is chain of title, property title, not chain of assignments. So there's the con. Then they go in, but for the existence of Connecticut General Statute 4917, any break in that chain would lay dead a hand on the note holder's ability to realize on its security. Now remember, the legal beagle from Yale and everything else talks to you about Article 9, 203B, and the requirements there for a clean title, which also is the same stuff that you'll find in Section 404 of the Saving Families Home Act, which is hidden and buried as a secret little amendment of the 1974 Real Estate Act in CGS 4910. Now, there's one other bit that I want to read to you from this book, because they know. And what's interesting about evil is evil's always got to show itself. So they know that they are doing dirty stuff. And here it is, because if you saw these pages of this book, you wouldn't believe the script that's written here. All right. Let's see. 4917. Oh, here's a little bit here I'll read that's kind of worthwhile. The trial court has specifically credited the plaintiff's evidence, which established its ownership of the note. And on that basis, coupled with the application of 4917, the plaintiff became entitled to its foreclosure decree. Okay, so the plaintiff won. Now, in concurring opinion, Judge Flynn acknowledged that 4917 controlled, but went on to lash out at a situation that resulted in the land records not properly reflecting the status of who was entitled to foreclose the mortgage. I see some obligation to point out, he stated, that no title search could find that City Mortgage Inc. ever received an assignment of mortgage from the mortgage holder of record at the time City Mortgage Inc. commenced this foreclosure. This raises the obvious question of what interest remains in the mortgage holder of record, and why did not the record mortgage holder, blah, blah, blah. And basically saying, even there, they screwed up on the assignments, right? They weren't complete in terms of even the assignment chain, but he let it slide. Now, here's where they show the truth. This is the BS part. The problem with those efforts, however, has been that they have failed to recognize that 4917 represents a codification of common law, going back to common law, that security follows the debt. If the statute in effect for more than a century were to be appealed, we would still be left with common law. And thus a note holder would still have standing to foreclose the mortgage securing the note, even if the mortgage had not been assigned to the note holder. Okay, that's not true. Now, and here's where they show that they're nervous. Ready? It is fair to speculate that such a proposal would be met with strenuous objection by the commercial lending industry, since the common law rule is fundamental to provisions codified in Article 9 of UCC. So they even right there admit that Article 9 is the driving force, and the driving force is title, UCC 9 title. And they don't meet any of that with these assignments because none of them are legal transactions. They don't have any legal transaction underneath them. And I'm sure about 99% of you can find that it's fraud. But this whole system is a giant, this is just one little avenue of stuff. This whole system, you can see, is a massive banking racketeering scheme. In the state of Connecticut, it was set up and it's been blessed by politicians, the legislative branch, everybody taking money from the banks and the lawyers and everything else. And they just run this machine over and over. It doesn't matter who you are. And once again, I'll take us back to the beginning. The Senate, it's Senate testimony. There's fraud everywhere. It's massive. It's years and years and years. There's nothing that's straight, as per the experts before the U.S. Senate Banking Committee. Okay? Yet we have no fraud here in Connecticut. None. Every foreclosure goes through.
Oh, everything is pristine and clean here. I mean, we have the most competent and intellectually sound
Just
individuals working diligently on our behalf every day to make sure that our will is done and that our laws are enforced. Connecticut is a leading
yeah.
state.
Not to get into politics or bring everything back to my case again, but in my particular case, one that's kind of noteworthy for across the nation, you've all been reading about Katie Hobbs, the new governor of Arizona. Well, as Attorney General, as Secretary of State, I wrote to her because I said the Arizona notary on my case was fraudulent. I wrote to her and she actually gave it to the Attorney General. The Attorney General for Arizona did an investigation on the notary on my affidavit of debt, and they came back to me letting me know that yes, she was invalid and so forth and so on, and I held this up in court and everything else, and our judges just ignored it. So from outside the state, by the Attorney General of the state of Arizona, signed with a letter certified by the Secretary of State, Katie Hobbs, my affidavit of debt is fraudulent.
And here in Connecticut, at the end of the day, when it's all boiled down, what did it mean?
Zero.
Zero, right. It's been completely ignored, willfully, consciously, deliberately ignored. Yeah. It's like we're in the world of make-believe here. And I hate to insert politics or even get into a controversial sort of social dilemma by making such bold statements here on Tyrant Slayer Studios, but that's what we do. The truth is not polished here. And this is the equivalent to pretending... I can't even make the statements here on YouTube.
I want to finish up with one other thing just to give... and I'm not...
Right. Al's been very patient. I got to say, Al's been very, very patient this evening. Al, it's a tremendous pleasure to have you here. You've gone through similar cases yourself. I have to kindly ask you there's a gear in your corner, or you can even get into your operating system settings in Windows down there in the right-hand corner by your clock, into your audio settings. Just turn down your microphone like 20, 30%. You're awful loud. It's I don't know if I can help with that on my end. I might actually be able to help. Hang on.
Okay, let me try that.
Yeah. Turn your mic settings down. You're really loud. But I just wanted to let you know we haven't forgotten about you folks. Thanks for sticking with us this long. This is a very deep dive into a very complex, very traumatic, and very serious, very real situation here. No, not quite. Go down a little further if you can. It seems maybe you made it. Oh, there we go. Now we're making progress. Go ahead. Key up again. Give me a cue. Go ahead. Give me a 1-2 check. Oh, that's perfect. Yes, that's much better.
1-2 check.
Yeah, you sound a lot better. All right.
I would just like to say I'm honored to be associated with Mr. Pritchard. He likes to be called Andy. So my situation started in 2010. I felt very alone for many years, and it's sad that I had to meet Andrew under such circumstances, but it's sort of like going to the pool hall, playing pool alone, and not having anybody who knows how to play pool. And Andrew comes along to be my pool partner. So it's a pleasure to have met Andrew under, sad to say, sad circumstances. Tim, is it possible to go back to the three? Yeah, thank you. But that being said, I'll let him follow up or finish up with what he was saying, and hopefully I can distill my presentation down to a few minutes.
Yeah, there's only one other thing that I want to leave people with, which I've recently learned because I'm also in criminal court. because of on my eviction, I was supposedly a criminal trespass, even though it's a civil matter and the police are not supposed to be involved.
Even though you weren't on the property when you were trespassed.
All of the above. And the 55 cops that came with a weaponized audio system and everything else that could blow out everybody's eardrum. Whatever. What is something that's really frightening to me, which I learned about, because we now see that the head of the Supreme Court, the Chief Justice, the top judge, okay, is completely operating the judicial as a business, okay, and is doing these corrupt things. Now, this gets really mind-blowing. Keep in mind, they don't want trial by jury.
What's this person's name for the audience?
She's now retired, 2018, okay? She's retired. She now sits on the board of some human trafficking stuff. And that's another thing that's kind of frightening for all those people in family court and all that. Human trafficking and all the stuff and things of that nature. During her time frame, there were like no one was busted. So in other words, is she the fox in the hen house? Is she allowing this? Was she allowing this stuff? I don't know.
So who has replaced her and essentially taken the helm of responsibility in regard to those?
I think somebody named Robinson. I forget who the Chief Justice is. But listen to this. This is really important. Really important. A grand jury, okay, that hears whether criminal charges are to happen or not, is supposed to be made up of the public, of the people. In the state of Connecticut, read about grand juries and it's going to freak you out. It's either one judge or three judges. Now, let's go back to the beginning. There's 240 approximately of these judges and judge referees, and I want to control Connecticut, and all I need is $240 million. I mean, all of a sudden, I can buy whatever decisions I want. I can buy. It's not people making these decisions.
You can buy a Senate seat, as we learned back in 2008. What did it cost? What was that guy's name? He just got out of prison not so long ago. He sold Obama's Senate seat. Right? Or, what happened? I can't remember the whole story, but those of you who know what I'm talking about know.
So the point is that, see, we the people are the check on this system. That's why you need a trial by jury. By the way, this is something that people don't know about in common law. Trial by jury in common law, whatever the result is from that jury, it is law across the nation. It is law across the nation. It was established and ruled on by the people. So trial by jury is significant and is much different than a jury trial and all these other things. We're a common law state. We're the Constitution state. And we, within all our articles of our Constitution, it says that a trial by jury shall remain inviolate. And we can demand it. I've demanded it. As a matter of fact, if you go to my court docket, docket number 794, there's a petition signed by 200 people for me to have a trial by jury, which they continue to ignore. Anyway, that's it for the night. I'm sorry for being so long-winded with everything, but
Andy, please do not apologize. You and your family have been through a series of severely traumatic events. I cannot imagine how you're able to keep your composure, your demeanor, your decorum. You are very powerful.
That's easy. Let's understand something. I'm here. God has put me in this position, and I'm not trying to get crazy spiritual, but that's why I've met such people as Albert That's how I've met you. This is a very much a good versus evil thing, and I don't even understand all the parts. I also want to let everyone know that as I'm standing in this particular breach, one of the main reasons I'm here and feel strongly and so passionate about it is because the foreclosure process is highly administrative, and that is the Achilles heel of these judges. Okay, that's where they lose their immunity. So for all those people that are in family court, probate, blah blah blah, all the stuff where there's these shades of gray, we blow this up. It blows up and cleans out all the other dirty stuff because they're doing all the dirty stuff and all those other things, and they're laundering the money through the foreclosure.
We're making this a call to action.
This is one big giant machine, money-making machine. And
this is now a call to action. I'm calling upon my fellow First Amendment auditing community. I'm calling upon all of the government accountability activists here upon the platform of YouTube, wherever you may be, wherever you're watching this video. It's up to us to present this to our friends, to our family, to our fellow citizens. It's up to us to put this on our platforms, to learn more about it, to see what the differences are between our states and how we can work together to overcome the absolute debacle that is a pure money grab through pure corruption at the highest levels. I mean, this is brutally, to be brutally honest, this is the biggest sort of
this man here, Albert Cusio, has been through it all in all the courts, in all the various courts.
They don't understand what a gem we have here to introduce.
And so he has a very deep understanding, and I firmly believe, once again, that this is, work from a higher source that's made the connection in all these things where these things are coming together as they are. And I just leave it at that. But anyway, Albert.
Thank you, Andy.
All right, yeah. Let's give Albert the floor, ladies and gentlemen, without further ado. One of the brightest minds that the state of Connecticut has produced through bad ways and good. We have Albert Cusio to enlighten us and give us his analysis of the deep dive we've been in this evening. And,
Thank you
I don't
so
know how
much,
to properly introduce you. Yes, have at it,
Thank
sir.
you. I would like to circle back to the beginning where you started asking Andy sort of about how does this start? What causes this to start? And I'd like to take one of my cases. Is it possible to put me back on? Yeah, that makes me feel more comfortable for some reason. And I must say, this is my first time on a podcast. And so if I make some mistakes, please forgive me. I'll try to make my presentation fast as possible, but I want to circle back. If possible, Tim, if you could pull up my one of my cases, I think.
Sure thing.
One document, it's 100 pages long. I hope you can pull it up, but it really cuts through the chase on how these things get started and who's.
I'm right on the I'm on the site now. I'll do a share screen just so for the folks at home, they can go and learn how to do this themselves. Okay. Folks, if you're interested in learning about this further beyond this video content this evening or whenever you delve upon it, this is how you do it. We're going to walk you right through that process. I'm going to go ahead and share that screen for you now. Bing, bada, boom. Here we are. All right. So
this is a housing court case. So I can give you the number, or
is ready? It Stanford? Yep. Is it Stanford, JD?
No, it's Bridgeport. It's
Bridgeport, FBT.
No. BPH, that's housing court. BPH.
Oh, BPH. Okay, hang on. I got to go back. Hang on. So you're going to want to go, for those of you at home watching, civil housing small claims. You're going to go to housing session lookup. You're going to go to docket number search. You're going to go to select location here on the left-hand side. You're going to go to Bridgeport, which is FBT. It says JD at the end. Oh, wait. BPH. Down here, you got to scroll further down. It says housing sessions. BPH, Bridgeport housing session. Category, Albert?
CV 22
22 for the year. And the number is going to be?
6011445-S.
-S. Okay, I think they have the S in there. You see under suffix, it's already in there for you. With that, we're going to go ahead and hit that search bar. Bada bing, bada boom. Straight Pile Surprise. Come up nice and quick.
Oh, that was surprising. Okay.
Yeah, Andy's took an awful long time.
Yeah.
All
So
right.
just a quick explanation with this. This is sort of the aftermath of a foreclosure action. Once they get an alleged judgment, then depending on how many people live in the house, they bring an eviction action in housing court. And that's why I'm in this. But if you look at that, if you look at the name of the plaintiff, P-01, it's clear. You just saw it. It was on the top. It talks about U.S. Bank National. If you go down to docket entry 105.
Okay, just give me a moment.
To disqualify the judge. In this case, the judge happened to be Judge Spader, who had a history of representing U.S. Bank National. Is that no? Let me double check. It might be. Let me see.
That's
Wait, no, I'm sorry, I got the wrong one. I got 105.1. That is my fault. Sorry, sir.
That's Spader denying it.
Sorry to jump the gun on you there.
Yeah.
Going to be a little anticlimactic.
Oh, it's 100 pages. It might take
motion for disqualification. I found it here.
Authority.
105, motion for disqualification of judicial authority, PB 1-23, coming up for you right here. There we are. I'm sorry about that, ladies and gentlemen.
If you look at the highlighted sections, you can clearly see that on the top of this page, the plaintiff is U.S. Bank National. If you scroll down to page 12, it will show you a couple orders from Judge Spader to show that he was involved in this case. He actually ruled neutral. There's those orders. So that if you go down a little, you can see he was involved in the case. A little bit more, you'll see his signature or his.
Oh, there it is. Walter Spader.
Okay.
An infamous name here in the state of Connecticut. What used to be left.
You scroll to the page 14.
Is going to be give me
just the docket sheet. That's the docket sheet. Then
I had it there. Oh, here we are. Yep. So this is recent. Okay. So this is as recent as August of 2022.
Yeah. So I with my skill set, I went back and I found that Mr. Spader, or Attorney Spader, before he became appointed a judge in 2015, 16, 17, he worked for the Marcus Law Group. Through that, I found his juris number, which you can't find through the system. You have to hunt and peck for it. But if you see page 17, I think you're on page 17. You can see you just went past Mr. Spader's signature as the attorney for the plaintiff. The attorney for the plaintiff. Wow. Who's the plaintiff in the case? If you go up a little, it's U.S. Bank National. In that case, there's 100 pages of proof of Judge Spader representing U.S. Bank National. So if you just slowly
That's insane.
Quickly scroll through, go down to page 38 or 39, and that will be all he represented U.S. Bank National 70 times as an attorney prior to hearing my case. So the likelihood of me winning was not winning or getting a fair. he would have to violate his attorney-client privilege, attorney everything to U.S. Bank National to rule against
God.
in my favor. So this was my motion to disqualify Judge Spader. But if we go back to the motion, the last section of the motion is page 8, and then we'll move on to the next.
Okay, page 8 from the top.
Yeah.
Okay, that's 1.
And you might want to read it because I'm a little nervous.
2, 3. You're all right. You're doing fine. 4, 5, 6, 7, and this is 8. Conclusion: Walter Michael Spader Jr. 4215229, attorney for U.S. Bank National.
Tim, let me give you a little explanation. This is the section that all of the judges use to disqualify or take away other attorneys' law licenses, which just happened to Norm Pattis, has happened to other attorneys.
Attorney Miller, you can read articles about Attorney Miller.
You have to keep in mind this basically says that when an attorney is in the presence of the court, if he violates any laws or rules, they should immediately call a hearing for that attorney to show cause why he should be allowed to continue breaking the law. In this case, Mr. Attorney Spader broke the laws in front of himself. But if you'd like to read this, you can.
But don't worry, the Connecticut Bar, or the Connecticut Judicial Review Committee is going to investigate itself and find no wrongdoing, and Spader will be squeaky clean.
If you could just read this one section, then we'll get to go to the other case where the fraudulent EMAP is.
Okay.
You want to just read this section quickly, or you don't have to?
This one here that we're on right now?
Yeah.
Wherefore, the defendant Albert Cusio III demands the court to order 1. Judge Walter Michael Spader Jr. recuse himself from this case. 2. Alternatively, pursuant to Section 2-45, to set a hearing date for attorney Walter Michael Spader Jr. to show cause why he should be allowed to violate laws and P.B. rules in his own court while he presides as a judge, and wherein he is witnessing the violation of laws and rules by himself and others in the presence of the court while he is presiding. That's insane. Quote, cause occurring in presence of court. If such cause occurs in the if such cause occurs in the actual presence of the court, the order may be summary, and without complaint or hearing, but a record shall be made of such order, reciting the ground thereof, without limiting the inherent powers of the court. If attorney misconduct occurs in the actual presence of the court, the statewide grievance committee and the grievance panels shall defer to the court if the court chooses exercise to its jurisdiction. 3. Order this issue to be immediately transferred to the statewide grievance committee and the grievance panel, because in this unique instance, an attorney and or former attorney Spader is violating the law and rules extremely outrageously, while in the presence of himself presiding as a, quote, judge, end quote, and has been damagingly ruling, quote, unquote, against the defendant in related cases. Different caps and fonts used to emphasize Walter Michael Spader Jr.'s multiple
now you know why I'm
conflicting
arresting him.
Well, right. There you have it, ladies and gentlemen. Clear as day, black and white, before your eyes, right here on Tyrant Slayer Studios. This is as real as it gets.
54170. CGS 54170. Andrew Pritchard's arresting Judge Walter Spader Jr. and the rest of the cast of characters. Okay. These guys are so far off the reservation. They're so dirty, so slimy. Oh,
this is big news. Where are our fellow activists? Where's the coverage? Where's the echoing among the community?
No. This is ridiculous. It's just gotten ridiculous. They are doing things in other courts. This is insanity. What is so mind-blowing is This is the Constitution state. Okay?
It used to be.
We got that name. The reason we got branded as the Constitution state is this simple. The fundamental orders of 1639, were laws and a treaty that was established to trade with England that was set up by Reverend Hooker, okay, which made us effectively the same as sovereign. We were at the same level as the king, okay? And it's one of the foundational pieces, some people believe, foundational pieces of the U.S. Constitution, thus the Constitution state. Why do I say all that? Whether you believe in God or not, this is how it works. God gives the power to man. And then we have our inalienable rights, okay? And then we give power within certain covenants to others to administer what they're supposed to do. If they don't do it within those covenants, then they're out. And guess what? I arrest Judge Walter Spader Jr. right now, CGS 54170. I formally have done it every which way. This guy is a criminal. He does not have the authority to be a judge. I am making an arrest without warrant. I would love to get in front of a grand jury, not of judges, not made up of judges, of people, and give them my case. And we will have a fair hearing and say, this is this, and that. And then people can decide. The people can decide where the power comes from.
Tim, I just want to let you know, this is the tip of the iceberg of my experiences with multiple judges.
Albert's been.
Well, we have a lot of common ground. I haven't experienced losing my entire life, but I have lost my daughter
My
to
damages
the
are
profit-driven courts.
My quantifiable damages without anything else, just what I was entitled to. I had a lease of commercial property to that I could sublease out for $12,000 to $15,000 a month on the Post Road in Westport, Connecticut, which that opportunity's been taken from me. The current owner of the property now is one of the cousins of a high-profile political person.
Now, this property, real quick, this is a property that's been in your family, right? Like this opportunity, this endeavor was
from the 60s, yeah.
Yeah, okay.
So,
and you've lost something near and dear to your family. Yeah. I mean, that's
the entire story would take 5 hours, but if you go to page 46 of this document, you'll Andy will get a kick out of this.
Okay, I'm heading there now.
Oh, is this one of these things that's going to make me bounce around?
No, but this is how I found his juris number.
Here we go.
To find all these.
Page 46.
Yeah.
Copyright information. Ha! What a very interesting thing to get into this evening, as there's been a lot of strange things happening here on the platform of YouTube to the tune of people actually jacking a content creator's content, such as myself, or to not name anyone, fellow content creators, and then actually claiming the rights to that content and filing copyright claims against the original owner. There are some very bizarre situations unfolding here, and the lack of oversight at Google and YouTube, where we're supposed to be valued as branded contractual partners in this rather lucrative.
Have you read the YouTube's agreements and stuff and everything else?
Oh, they just changed, but they didn't tell any of us that they've changed.
But some of the stuff they can
listen. I can lose my channel in the first 8 seconds of a video.
All right,
going forward here.
I better
Tim,
not.
Could you just read the first couple paragraphs of what Mr. Spader used to be good at?
Okay, this is coming to us on page number 46 out of 113. provided to us by Mr. Al Cuzio. Folks, if you're just joining us, we're talking about foreclosure and racketeering here in the state of Connecticut and throughout the nation. This is the MarcusLawFirm.com. Copyright information, again, provided courtesy of Mr. Al Cuzio and relative to his personal experience and case in this state. Highlighted just below, it indicates to us that the website designed by Walter M. Spader Jr. using Microsoft Front Page 2000 and Adobe Photoshop version 3.03. All text was...
Photoshop is what I wanted to point out there. Just make a mental note of that. If we could go to...
nothing nefarious to come.
The underlying foreclosure case is a different docket number.
Okay.
If you could pull that up, if you could go back to, this is a civil docket.
Sure. Okay, go into a different case detail. Okay, just give me a moment here. Bada bing, bada boom.
What we're going to be talking what we're going to talk about here is condition.
They'll just Photoshop what they need into the record.
Condition
one way or
precedent.
another.
The condition.
You know, I could actually find some money in that. I am a hell of a Photoshopper myself. Listen, Connecticut, if you're looking for money and you're committing fraud, I'll pretend I don't know. You know, I'm just kidding.
Andrew, would you like to see the 100 pages of the whole history of the...
What's our docket number, sir? We're in BPH Bridgeport Housing Session?
Yeah, CV 14.
14. Okay, we're going back.
Dash
8 years.
Because I prevailed multiple times against Bank of America. CV 14.
CV 14 and the number, sir.
6043 796.
Okay. BPH CV dash 14
FBT.
Oh, I'm sorry.
Yeah.
I'm sorry. Let's try that again. Ooh, okay, and we got it. Let me get her up on screen for you, sir.
If you can go to... Andrew should get a kick out of this.
Where is it?
Docket entry 40.
Okay, docket entry 340.
This is just supporting some of what he spoke about earlier. Spend a minute on it.
Well, this is why we have you aboard, because I knew you would be keen to specific information as it was being divulged and have something relative to...
This is the history of the bench bar committee from the beginning, from 2007.
Really?
You can just scroll through it.
Roger.
You can see how
Okay, here we go. I got it.
If it can...
Wow.
Okay, this is 80 pages long. We're on page 2 of 80. This is the Foreclosure Committee meeting, Thursday, October 25th, 2007 at 2 p.m. That's 1,400 hours for all you military folks out there. Attorneys Conference Room, 231 Capitol Avenue in Hartford, Connecticut, the former insurance capital of the world. Connecticut was actually once renowned as the richest state in the Union. I would argue at this point we are perhaps the most communist, Marxist, and single most dependent state in the Union.
You can scroll through this pretty quick. I just wanted to show that Andy that we have backup of what he was saying. You scroll through it and just look at the highlighted sections, particularly all the names of the judges and the attorneys. And this is from 2007.
Oh, Mintz.
Yeah,
Honorable Douglas C. Mintz.
Oh, yeah. Mintz was right there. Mintz is...
Ooh, there's Liebert. There's Liebert.
I know. Yeah, they're all there. Yeah. This is perfect.
It's the good old boys network.
Albert, I need to get this. I want to put this in my case.
Okay. Ladies and gentlemen, this is a prime example of what I'm trying to accomplish here. Not for selfish means or profitable gains, but to actually help make a better future for my kids, help Andy with his case, help Al with his case, help you, help yourself. Let's help each other. This is a prime example of what we're doing. I've essentially just created a hub for two people to, find that, wow, we've got some valuable mutual resources here. We need to talk. That's what this channel is all about. It's about the wealth of knowledge and information that we can use
Tim, if you go to
and
page
utilize to put in practice.
If you go to page 14, I think that will cover most of the names that are familiar.
Minutes of the bench bar foreclosure committee meetings, Wednesday, June 18th, 2008. Hands out to committee members. Agenda draft of minutes of December 6, 2007 meeting. Recommendations of process subcommittee with notice and proposed language remotion to open judgment. Quote unquote committee subcommittee recommended revised uniform procedures and forms for committees. Jesus Christ, man. I mean, this is like just some housekeeping here at Tyrant Slayer Studios. Some general housekeeping. Members and attached Honorable Douglas C. Mintz, Chair. Honorable Salvatore C. Agati. Geez, I don't want to butcher these names. Attorney Adam L. Bendit.
These two names are the owners of the biggest foreclosure mills, Hunt Liebert, formerly Hunt Liebert, and Bendit and McHugh. Hunt Liebert has over 200,000 foreclosures that are active on the Judicial website, and I think Bendit and McHugh has I don't know, 50,000, like half as much. So there's about 300,000. However, if you were to look up people's names, they won't show up because they find So that being said, let's move on to the next. Just a quick question for the future. Can you do a Control F to find something in this document, Tim?
I can go to a specific page if you have something. I do have.
If you hit Control F right now, it should come up with a.
Yep, I bring up a search field. Okay,
right, so
what am I looking for?
Put in the word Wells, WELLS.
Okay, and I've got Wells Fargo Bank National versus Mellon.
I don't have
Milan. Wells Fargo Bank National versus Milan. Attorney Karen, judgments.
So,
Attorney Liebert. Judgments.
All I'm trying to point out is Wells Fargo's involved with the bench bar and it's a whole nother show.
The conflicts of interest, the criminal conflicts of interest that exist in
business
as usual. I just want to
let the public know that Wells Fargo is the financial advisor for the judge's pension plan that holds $79 million just for Wells Fargo so if you were to go in front of any court regarding a plaintiff named Wells Fargo, the judges jump out of their seat whenever you say that they're.
You mean Wells Fargo might have seized my house?
What?
Yeah. Wells Fargo.
That's a whole nother show. I have the documents. So. They settled. The Attorney General settled with Wells Fargo for multiple reasons. They're very connected, I should say. So let's go to the next. Let's go to the next.
Okay.
Motion to dismiss 335. This is a motion to dismiss for EMAP because they never met the condition precedent to bring the foreclosure action in my case.
Okay. Got it.
This
is a memorandum of law in support of motion to open and vacate judgment.
If you just scroll through this is the document you use to have a case dismissed for EMAP.
Okay, let me start at the top. I'm going to give a nice smooth scroll for the audience here. This is Exhibit A1. The people can read through this. Go ahead, provide the best commentary you can. Give the people some insight and. What would you say is the most important, element to what the people are reading through here?
In Connecticut, to bring a foreclosure 60 days before you bring the action, you have to send an EMAP. It's basically a letter from the plaintiff, from the bank, to the defendant,
Yeah, EMAP.
Andy, you want to explain it?
And that has to be certified mail, right? Does that have to be certified?
EMAP stands for Emergency Mortgage Assistance Program. It's a federal law. It's a federal law that must be met.
Okay, that being said, Tim, can you scroll a little faster? So I want to get to the
Sure.
So in my case,
give me a specific page. We got 5 pages here. Okay, go ahead.
Okay. Let me bring up something else that's more important. So the next thing is the motion to dismiss.
Take your time. You're cool. Collect yourself. Okay. Get your, make sure we're cool. Al's first time live on a podcast. He's doing fantastic. These are real people in the state of Connecticut experiencing very real things that cause a lot of real trauma and a lot of real pain and real damages to their family, to their income, to their day-to-day.
Document entry 110. I'll just point it out really quickly.
Okay, let me go ahead and get that up for you.
Affidavit to show that they sent the email.
Affidavit of compliance with EMAP.
Yes.
Got it. Okay.
So, in my instance, they never sent. They never sent it, and it says based paragraph 2.
Paragraph 2. Based on Bendett and McHugh, pieces. Okay, so that is not a relative name to the McHugh I'm thinking of. I was thinking of MCCUE. So, okay, that's totally different. PC's business records and its regular business practices. The plaintiff has complied with the provisions of Connecticut General Statute Section 8-265EE parenthesis A, also known as Public Act of 08-1767 by Bendett and McHugh, PC, given on September 12, 2011, to all mortgages a notice containing the information required by said statute. More than 60 days have passed since the date of the said notice, and Bendett and McHugh, PC, has verified by direct inquiry with the Connecticut Housing Finance Authority, CHFA, that check. No mortgager submitted an application for assistance to CHFA pursuant to Connecticut General Statutes Section 8-265EE within the 60-day period after said notice was given, or
okay, Tim,
CHFA denied the. Okay.
That notice was never given. I'll send you to the order. The order number is 331. 331.
331.10. 331.50. Order.
Okay.
Okay, roger that.
This is after
just a moment, ladies.
This is with an order that placed after a hearing where I pointed out to Judge Spader while keep in mind this the plaintiff was U.S. National Bank, his former client, that he's issuing orders on. And if you read the last few paragraphs, I explained to Mr. Spader and most of the other cases that were winning and having their cases dismissed because of EMAP, and they had to prove that it was never sent. I never even received the notice.
This is short enough. I'm going to go from the top. Yeah, there was certified mail, allegedly, certified mail that came to my house. And I've got, proof that the postal worker never even knocked on my door, just filled out a card saying no one was here, or the property was inaccessible.
To sum it up, this basically,
no notice.
This basically says after I proved that there was no EMAP notice sent, because it's not even in his affidavit. I didn't have to prove anything. Your Honor, I win, is basically what I said.
Order denied. The defendant has moved to dismiss the plaintiff's case, alleging that the record before this court does not reflect that the plaintiff ever sent an EMAP notification pursuant to the Connecticut General Statutes.
Another reason that Judge Spader's arrested.
The plaintiff objected, indicating that it had filed an affidavit of EMAP compliance shortly after commencing this case on January 20th, 2015.
Sheriff Andrew Pritchard here arresting Judge Spader.
This matter has been heavily litigated since that affidavit.
Actually, can you two appoint me to be a sheriff? I think two maybe.
Listen. This is what the first of all, I want to talk, and this is big news for the community too. I'm going to go ahead and just give a little sliver of what I've been quietly kind of stirring in a pot for a little while. Okay. It might seem like I'm inactive around here at times, but I'm a very busy man with a very large family who is very concerned about the ever-encroaching government that is seemingly ruining the future of my children, right? So I'm actively on a day-to-day basis, whether I'm here publicly or not, everything I do is calculated and filtered through my modus operandi of changing that future. Right. And one of the ideas I've had is becoming constitutional sheriff. One of the obstacles I faced was, how do I do that in this corrupt communist Nazi nanny police state? How do I do that? Well, Andy, Al, I think you two would make very profound constitutional sheriffs here in the state of Connecticut.
Oh, gosh.
And you would operate strictly in compliance with the laws and the Constitution of our state and our nation. And I would absolutely wholeheartedly support your efforts in that endeavor. Now, the way we actually do that, in my surmising of the logistics of all of this, we need at least 50,000 signatures in petition to actually bring to the Secretary of State and say, hey, the people want an election. They've had it. We want sheriffs now. And one of the newer things I've been delving into is, do we want to be, constitutional sheriffs of our county, or is there an option to be like statewide sheriffs?
No,
where
I don't believe. I think, I think a sheriff has to be of a county. But a sheriff has the authority to go anywhere in the state.
It would be okay if we were county-based in our elections, but I think our jurisdiction should be pooled in a kind of spider web of intel and data.
No, you can operate. A sheriff can operate as a legal, a law officer anywhere in the state. So in other words, our sheriffs, the sheriff, back when we had sheriffs, the sheriff of Fairfield County, for example, could go arrest the governor.
Yeah.
Up in Hartford. He could also arrest Judge Spader, who's hanging out in Waterbury now.
Or the chief judicial marshal, like Donovan Murphy.
By the way, I want to make something clear. Since they did away with sheriffs, all that power came back to us. So I'm not joking around when I say that I'm arresting Judge Spader. He's committed felonies right before me, and so have these other judges.
And I'm not joking around when I report it. I've taken a lot of flack. There's been a tremendous level of speculation and criticism that has been pouring in.
Hang on,
the dams have broken.
My 100-pound deputy is trying to get in my room.
Hey, let him in.
Tim, this
Al, let's get
This just because you guys off that, this might be very helpful. Could you keep that document on hold? But you could look up the Marshals State Commission. It's called the Marshals Commission of the State. It's an executive branch of the governor. The state marshals. Keep in mind, most people don't realize the marshals you see in the courthouse.
It's the SMAOCT is an organization that represents and organizes the state marshals throughout Connecticut. They're organized through AFSCME. Jesus Christ, we're gonna have to find out whatever that.
Are you at the Marshals Commission of the State?
I did a Google. I'm in the midst of Google Marshals Commission of the State Connecticut, and
When
I've
you
got
click on it-
smaoct.org. Is that what I'm supposed to go to here?
On
Okay,
the
let me
left,
see.
it's
I'm going to share this.
It's the Attorney General's opinion in 2000. That was Mr. Blumenthal at the time wrote the opinion that we didn't need sheriffs, and that was the letter that was used to convert our sheriff system into the marshal system.
You mean
I
during the
emailed
time?
it to you.
Yeah, during the time of the corrupt governor.
Send me a link. Just put the link in the private chat here, right here. And
How do I do
we
that?
did away with sheriffs in the year 2000 when we had
Put it
corrupt
right here.
governor.
Okay, here we go. It says it's locked. Okay, there we go. Here we go.
private chat is locked. Oh wait,
No,
I see
now-
it. Private chat.
Let me get it.
Hello, Moto.
Oh,
Oh, here we go.
it's so obvious.
So-
All this stuff is so obvious.
Click on that.
Got you.
Can you
got
show
you.
that to your
Straight power surprise. All right. Connecticut official state website, Marshall Commission. You with us?
People
you got us?
don't-
We're good.
Can you just read the first paragraph that explains the state?
The overview?
Marshals?
All right. The State Marshal Commission is an executive branch commission operating within the Department of Administrative Services. What a joke that place is. With independent decision-making authority. Who grants them that authority? Are these like unelected czars? This is aggravating me to the umpteenth degree because it directly triggers a multitude of memories of experiences I've had in the last 2 years just trying to stop my daughter from being molested by a bunch of transient heroin addicts. Okay. So anyway, the commission conducts several core functions, including setting training requirements, professional standards, audit policies, disciplinary protocol, restraining order rotations, and administrative procedures for the efficient and fair operation of the state marshal system. By statutes, regulations, and policies, the commission also is involved in many functions, including but not limited to setting training requirements, professional standards, audit policies. Wow, this is the most redundant paragraph I've ever seen in my entire
But
life.
Tim, what people don't realize when the state marshal comes out and he says, "Oh, I have an order from the judge. I have an order from the clerk." That's all bullshit. He works for the governor of the state of Connecticut. Once that
That's where the orders come down from, right from the top.
once that paperwork gets signed and the marshal comes out and he says, "Oh, you got to go back to court." No, you got to go to the governor because that's the person. He's the agent and the governor is the principal. Or
That's why Governor Lamont's being now sued in my case, and then on top of that, one of the people in my case was impersonating that they were.
Well, look at how his wife is taking advantage of that office to
Tim,
make all these contracts.
Click on the Attorney General's opinion letter. It's on the left column.
Okay.
If you want to open that PDF, that's what canceled our sheriff. The PDF.
I got you.
Go
This
down
is
and
it
look
here?
who signed. Yeah. No, go down.
Connecticut
down.
State Marshal. Okay.
Go down a little bit. That's just bullshit. Oh, can you blow it up? That's the letter. That's the opinion Attorney General in 2000 requesting or that the state sheriffs be dissolved and turned into the marshal system.
Oh my God! Look at this shit. This is big. We're gonna have to do a whole show on this document alone.
Let's go back to
We'll
that.
call it Ignorant Citizen. This will be the first
Let's go right
episode
to
of Ignorant
let's go to
Citizen
the last paragraph.
officially.
If you go to the last paragraphs of Judge Spader's order, then I'm going to bring up the fabricated EMAP that was created 11 years later or 8 years later.
All right, hang on.
And then we'll wrap it up.
And this is back in housing, correct?
Oh, yeah. No, that was in the
Okay.
that was in the foreclosure case. You got to start over.
Yeah, I closed that window by accident
Jeez.
in the other business.
The FST case.
Okay, got you.
And we might just jump to the fabricated EMAP and then go back. And I'll explain that.
FST Stanford.
Yes.
CV and the year is?
14.
And that juris number again? I'm
not
sorry,
like
the number again?
all these other.
Yeah, I'm sorry.
I'm not like.
Was
Good
it
as Andrew, I'm
601
sorry with the
601
numbers.
6011445?
No, it's
6043.
601-43796-S.
601-4379-S. FST CV 14 601-4379-S is not found or is.
No, slow down. It's CV 14. You ready? 604.
Oh, I'm sorry.
43
604.
43796-S.
Gotcha. Oh, that's not found either. 604-4379.
Wait a second.
Stanford FST
No,
CV 14.
FBT. Bridgeport.
Oh, Bridgeport. I'm sorry. That's my fault. FBT Bridgeport CV 14 604-4379-S.
43796.
6.
This is a
It won't let me put it in there.
This is a
604-4379. It won't let me enter the 6. It's only let me enter 7 numbers. Here, hold on. Let me refresh this page. Ladies and gentlemen, I apologize.
This
We
is a
may be
cliffhanger, but it
experiencing
might be worth the wait.
Okay, selection. Bridgeport. FBT.
Yes, CV.
CV. Year 14.
Yes.
And our number, once again.
6043796. Technical issues.
There we go. We got her. And what specific docket number here?
Okay. This is the notice of compliance. You know what? Go right back to that order again. It was 331 dash. Let's finish that in order. 33150 denied.
Didn't I? Doesn't matter. He's not a judge anymore. He's under arrest. He doesn't have the authority to act as a judge.
Start reading from unless the litigant or the defendant. You see what it says? Whatever.
The defendant has moved to. The defendant has moved to dismiss the plaintiff's case, alleging that the record before this court does not reflect that the plaintiff ever sent an EMAP notification pursuant to Connecticut General Statutes 8-265 EE. The plaintiff objected, indicating that it had filed an affidavit of EMAP compliance shortly after commencing this case on January the 20th, 2015. The affidavit averred that a notice was sent and no mortgager applied for EMAP assistance through CHFA. Absent from the affidavit was a copy of the EMAP letter. This matter has been heavily litigated since that affidavit. Following a number of motions to dismiss, 2 federal removals, and a bankruptcy petition, judgment entered following a trial before judge. THIM, as evidenced by a memorandum of decision released on October the 4th, 2018, docket entry number 247, the judgment was appealed and the appeal was dismissed. The defendant's present allegation that there was no EMAP compliance by the plaintiff is based on an affidavit that has been on file for over 3 years prior to the Judge THIM entering judgment. The court reviewed the trial file and exhibits entered therein. The plaintiff did not submit EMAP letter at trial, only having entered the initial demand letter sent to the defendants. The court, after hearing this motion, ordered the plaintiff to e-file a copy of the EMAP letter, which it has since done. Quote, unless a litigant has shown an absence of subject matter jurisdiction that makes the prior judgment of a tribunal entirely invalid, he or she must resort to direct proceedings to correct perceived wrongs. A collateral attack on a judgment is a procedurally impermissible substitute for an appeal. At least where the lack of jurisdiction is not entirely obvious, the critical considerations are whether the complaining party had the opportunity to litigate the question of jurisdiction in the original action, and if he did have such an opportunity, whether there are strong policy reasons for giving him a second opportunity to do so. Our Supreme Court further explained that such a collateral attack is permissible only in rare instances, when the lack of jurisdiction is entirely obvious, so as to amount to the fundamental mistake that is so plainly beyond the court's jurisdiction that its entertaining the action was a manifest abuse of authority, or the exceptional case in which the court that rendered judgment lacked even an arguable basis for jurisdiction, end quote. Citations omitted, internal quotation marks omitted. Bank of New York Mellon v. Tope, 202 Connecticut, 540-549, 2021. FBTCV 146043796S. The defendants have not established that the court, in rendering the initial judgment, lacked jurisdiction in quote-unquote in an entirely obvious way. Henceforth, the affidavit of EMAP compliance, although not the actual letter, has long been a part of the court file. Had the defendants wished to, they could have challenged the letter and any motion to dismiss prior to judgment entering at trial, and or especially as required during the appeal of the initial judgment. While Mr. Cusio advises in his affidavit that he never received the EMAP notice, the statute does not require proof of actual receipt. Wow, how convenient. But attestation of the plaintiff sending the notice, that's what it requires. Their counsel's affidavit from January 2015 is compliance thereof, only further evidence when providing a copy of the actual letter at the court's request. The motion to open and the motion to dismiss this matter for failure to comply with EMAP requirements is hereby denied. Once again, ladies and gentlemen, this is Judge Walter Michael Spader Jr. This black and white, as plain as can be, as real gets. Ladies and gentlemen, this is the tyrannical nanny police state of Connecticut. We are being dominated by a bunch of criminals, and innocent men and women are losing their properties, their assets. They're losing their livelihoods. They're in an uphill battle under the illusions of justice that are, and given a false sense of resources and recourse in a system that has been set up to predetermine the outcome of what's going to happen, no matter the facts, no matter the truth. It's all about the money. It's all about the business. This is big business in
Tim,
Connecticut, and it.
Excuse me, Tim. I'm sorry. In that order,
yeah, go ahead.
It's not that order. I'm looking for the Judge Walter Spader ordered that the plaintiff keep in mind this order was done on February 25th. That's a Sunday. So
I got it.
But I'm looking for an order, or in that order where he orders the plaintiff to by March 3rd to comply with his order. If you go to 336.0, that's the notice
Okay.
of compliance, which is I think it will explain. This will tell.
Got it.
It's on February. It's another order, the 33110 order. If you go back to the 33110 order, that Spader tells the plaintiff he has to provide the EMAP later. 33110. Where's that?
Got it. Oh wait, no, this is 3310. My fault. Hang on. Folks, this is live. So, I mean, there are going to be mistakes on occasion. We don't have any makeup on. No one wonders
this
what
was the original
Al and I are
order.
going to wear.
This was the order I wanted you to look at first. I'm sorry. If you read the last two paragraphs, it explains it.
Order number on that again. I'm sorry, sir. One more time.
33110. Wait.
Got you.
33110.
Got you. And here we are.
This is the on the start reading on the surface. That's the third
Ordering.
paragraph.
This isn't, ladies and gentlemen. This is an order. First of all, if you're just joining us, this is Mr. Al Cusio. We've done a deep dive with Mr. Andy Pritchard, a longtime resident of Norwalk, Connecticut, whose whose property has been illegally seized by the state of Connecticut and a number of racketeering judges. And what we're doing now is bringing up relative court record, relative information in which Andy and people like him can find strength and common ground, and perhaps the means to get the justice that they've been seeking. This is a very serious ongoing matter that's taking place and sweeping across the nation. And we're taking a very serious look at it. I'm wondering why nobody else is. You guys are really perplexing me here, man. Like, this is about government accountability, right? Well, this is a great way to help some struggling people hold their government accountable. So let's get behind these men. Share this link and
I
the
think
videos.
I'm sorry, but I think you need to read this whole thing because it has more explanation. Sorry, I put you.
Sure. No, I understand. The foregoing having been heard by the court is hereby. Here is the order, ladies and gentlemen. And this is February the 27th, 2022, Bank of America, N.A. versus Albert Cusio III, Judicial District of Fairfield at Bridgeport. The court has reviewed this file as it noted it would do at oral argument on February the 25th, 2022. The court needs clarification from the plaintiff on the alleged EMAP notice. By affidavit filed with the court on January the 20th, 2015, the plaintiff's attorney advises that the plaintiff complied with EMAP by a letter dated September 12, 2011. No copy of that letter is in the court's file. The court advised that it would review the exhibits presented to Judge Thim at trial in 2018. The court notes that the transcript does not show the submission of an EMAP letter, and the letter that was submitted to the court as Exhibit 5 was described as a quote-unquote demand letter from Bank of America. The letter is dated May 17th, 2011, and was indeed sent by Bank of America. The green card was signed by the second named defendant. The letter itself does not provide EMAP advertisements, although it does indicate other available programs that could have assisted the defendants. On the surface, there is nothing improper with the 2011 EMAP and demand letters being issued to commence a case with a 2014 return date, especially when there has been no change in ownership of the note and mortgage from the time of the EMAP letter to the commencement of the action. And although Judge Thim made a finding of compliance with all conditions precedent at trial, this court still requires a copy of the letter to be on file with the court. This submission shall be from attorney Knickerbocker, despite the defendant's protestations that he does not have authority to file pleadings in this matter. He does. He is counsel to plaintiff and its assignees. Attorney Knickerbocker is also correct that the affidavit has been on file since 2015. The matter has survived appeal, so generally the judgment is final and the belated challenge to the judgment is inappropriate, since the issue could have and should have been addressed earlier. Nonetheless, the court is substantively addressing the matter. The court expects the letter to be e-filed on or before March the 4th, 2022, and it will issue a ruling on the motion to dismiss and related pleadings shortly thereafter. This was mailed to the appearing parties on February the 28th, 2022, under docket FBT CV 146043796S. That is signed by Judge, once again, Walter Michael Spader Jr. An infamous name here in the seemingly nefarious and criminal conduct carried out within our weaponized judicial system here in the state of Connecticut.
Let me just point out two things. He omitted the fact that the most recent order that he should have went back to was issued by Judge Bruno, who has been removed and has been for incompetency and multiple other reasons. Andrew could go into that. And they skipped over Judge Bruno and went back to Judge Thim, who I did a motion to recuse because he was the judge who was in my probate case. And I won't get into it, along with other judges, which basically they sat on their hands while two attorneys ran up $900,000 in bills to evict, trying to evict me from my commercial property. And they did not, the receiver never posted a bond, which is illegal. They knew it, and they let them continue to act without the proper mandatory bond to bring an eviction action and to bring the original action. I prevailed on that eventually, but now Judge Sprader is bringing up an order from Judge Thim, who ruined my life in another case wherein I prevailed and proved his orders were wrong. So that being said, let's go to the next document where they manufacture, where I believe they fabricated the document to comply for the March 4th deadline to provide an EMAP letter, and when they say in 2011 there was a letter, there was one point where we worked on a mortgage modification, which that would have been the demand letter for then. And I believe we actually, I'm not at liberty to discuss it, but we prevailed in 2011. So that's all bullshit. Excuse my friend.
You know, I find it commonplace in the community that when a pro se litigant, when an independent, strong-willed, knowledgeable man like yourself essentially overcomes the powers that be, if you will, these people are often forced in settlement agreements or otherwise mediated settlements, if you will, to shut up. Like there's not necessarily a gag order associated with it, but there's a level of confidentiality that goes along with all of this stuff. And I find that to be disgusting. Disgusting. The truth needs to be marketed. The truth is the most valuable. And the truth is truly going to set everyone free. I mean, there's no greater understatement.
337 is the notice of compliance that was filed just on just on March 4th, the day that it was required by Judge Spader, if you go to 337, which
Got you.
is in
337 even 33700. Got you.
notice. Wait. I'm the wrong. I need.
Okay, yeah, double check. Notice defendant requests court take judicial notice of motion to open.
That's not it. Hold on.
Oh, that's a fee waiver request. Yeah, we don't want that.
We want a notice of compliance. Hold on.
While he's looking that up, I just want to read this.
336.
Yeah, I got to use the John. On a rare occasion, I will give the command to our guests, and I think you guys can handle that.
Can you just pull up that
336?
so. Can you pull up the 336 just so we have something to look at?
Absolutely. 336. Notice of compliance. I got it.
Well, so if you scroll down to Exhibit A,
Roger.
this is
Exhibit
the letter.
A.
Exhibit A, and if you look at it really closely, now it's digitally created because everything lined perfectly.
Right. This is not an inked. This is not a normal physical document. This is all digital.
Normally, an EMAP notice is sent from ink, and it's like crinkled up and scanned in that they sent it. And this document, Exhibit A, if you right-click on it and inspect it, if you inspect the metadata, it was created on March 4th, 2022. It's not.
Oh, can you see that? Can you see me doing that? Is that coming up? Oh, that's not coming up on screen. Hang on, let me share.
It might
what
be
I'm doing here.
inspect.
I am inspecting the metadata. I'll take a screenshot of it. I will put this information up on the community page.
Maybe
We will
Andy
echo
can.
this.
So this is it. This. I want to leave all on this. If you want to start wrapping it up, or if Andrew wants to.
Sure, I'll read it from the top.
Make a conclusion.
Via certified mail, postage prepaid from Albert Cuzio, Melissa Pasatelli, Cuzio. Okay, we don't need.
No, you don't have to read that whole
Dear
EMAP notice.
All right.
These
This
guys
is,
just create
this is
this
branded
bullshit out of nowhere. This is fraud.
all right.
Just fraud.
But Andrew would verify
This is
that
what they
it's
use to
normally,
jerk the people around.
Yeah.
yeah. But you can see it's not signed. It perfectly scrolls up and down straight. And
Yep.
Yeah, it's not signed. There is
I
no
have
ink signature on that.
And I have a motion to dismiss case, which would unravel the eviction case.
Oh, he's really important. This guy's really important. He's got 2 forward slashes before his magical number.
Yeah.
Yeah.
So that
Yeah.
wraps it up for my experience in the foreclosure arena. I do have experiences in family court.
Folks, you want to hear more from Al? Do you want to hear more from Al? I think Al could be a very viable resource to the pool of knowledge that the people need. I think Al is,
everybody for hanging in there so long. But I think this is valuable information that people need to be aware of.
It's very difficult to do such a long segment. We're up to 2 hours, 38 minutes, and 11 seconds at this very moment. I could trim this up. There's ways to kind of create some noise. We, as the inclined individuals that we are, have a responsibility to do something with the level of consciousness that we're operating in. I don't want to sound conceited. It's so easy to come off as conceited. But really, what I'm trying to say is, Al is cut from a very distinguished cloth. Andy's, their life experience has enthralled them, has forced them into the trajectory that they're on, right? And in that trajectory, they have gathered, like a snowball effect, all of this knowledge based on real firsthand experience. And they're going to know better than anyone how to help. And they're not going to charge for the information. They just want to help. They want to be able to help themselves.
Never.
Right.
No money.
We're not trying to make money here at Tyrant Slayer Studios. We are the real deal. These are real victims affected by real crimes being perpetrated against the people by our state, by our systems of government.
I would like to finish with one line statement that the Supreme Court. The Supreme Court has warned, because of what appear to be lawful commands on the surface, many citizens, because of their respect for what appears to be the law, are cunningly coerced into waiving their rights due to ignorance. U.S. versus Minker, 350 U.S. 179187. I think that's significant. It speaks to the fact that, listen, when I walked into court the first time and everything else, I'm like, okay, these are judges and lawyers. And then I started investigating, and then I get threatened, and I'm like,
it's almost as bad as the blind trust. You know, there's an individual in a black cloak in a courtroom. There's an individual in a white lab coat in a medical setting. People have this sort of inherent...
Oh, it's conditioned, yes.
They have an inherent naive sort of level of trust based on that presentation of that individual. Oh, he's got his PhD on the wall.
Right.
There's a stethoscope over his shoulder, and he's wearing a white lab coat. He must know what he's talking about better than me. So people just...
Right.
Their ignorance will prevail and work against them if they are not able to think critically about what is happening. And this is how a lot of America's, I'd say, day-to-day society works. It's not just on a governmental level. It's not just in our bureaucracies. There's elements of our regular day-to-day markets that operate like this.
I'm going to do it.
Tim, there's one rule, law. If a judgment is procured by fraud and or mistake, it shall be void. So in this case, after showing you everything, keep in mind,
like my family court case,
the foreclosure case, wherein they fabricated the EMAP. They used that fabricated EMAP to be able to get a judgment to start the eviction case. But that's in the same case where Judge Spader, I disqualified him. So all of the orders that he made in the foreclosure case for U.S. Bank National, I would ask Andy, were they procured by fraud or mistake? Do we know the answer? Yeah.
Right.
Either one.
All right. Well, I'll pose this question to the two of you
Judge
to
Bruno
close out
might
tonight.
have been by mistake because she was incompetent, but by Judge Spader, we know the answer. So all of those, I'm in that case, all of those judgments that he ordered in that case, including the denial of the EMAP.
Well, anyone with two brain cells to rub together can come to that conclusion. Yes. I will pose this question in closing to the both of you, and you can answer best you can if you'd like. Geez, how do I pose the question? What do you guys think about leaving the state of Connecticut to address these issues? Is there any remedy for this, this level of corruption, right? You can't rely on our own internal resources because clearly they have been compromised, right? So is there a remedy in Washington, D.C.? And if you believe there is a remedy in Washington, D.C., what is that? And how do we begin tapping into that resource as most optimally as efficiently as possible, so that we can maximize the utilization of that resources, put them into practice, and perhaps overcome the obstacle here locally? Can we bring outside resources into the state of Connecticut and manifest the oversight that we need without actually having to become sheriffs ourselves? Do we actually have to risk our own lives and become sheriffs? to do this stuff? Like, what do you see? Like, what are our options?
Me and Andrew seem to. This is what I should say. One issue that me and him have taken different roads. He's taken either the high road or the low road. I've tried all of the other options. Federal
On a local level, or have you gone?
I've gone.
You've exhausted all the resources.
I've exhausted all. Yeah, I exhausted all the remedies in Connecticut through the appellate court. One thing we didn't touch on is how they fabricate and switch the narrative of the transcripts. So by the time you get to the appellate court, all the tricks they play on you, you can never have a perfected record. So by the time you get through the correction process of the transcripts that are skewed,
the predetermined outcome, right? The predetermined outcome that they're after prevails.
That's called railroading. Railroading.
Mm-hmm. Yeah. So, for instance, on New Year's Eve, they issued an order saying they were going to, maybe even in this case it might have been, that they were going to dismiss my case because I was deficient and I didn't provide the certificate of completion of transcript by the court reporter. I went in at 2:00 on New Year's Eve thinking I'd have plenty of time. The court supervisor's not here. She's the only one who can sign this document. What do you mean? What do you mean? There's nobody here that can sign the document? So I
get that sort of stuff all the time.
I filed it in the clerk's office. I got it stamped to prove I was there. Everything else. New Year's, the day after New Year's, appeal dismissed for failure to comply with the deficiency order, which was total bullshit.
Right. Lest we forget, back to what Andrew touched on about 90 minutes ago now, we as sui juris pro se litigants, we're a threat, right? We're treated and portrayed and perceived as a threat. The educated man who knows how badly he's getting screwed is treated as we're being. It's like we're being persecuted.
No,
there's no answer. There's no answer to your question. I don't think, because the referee, if you can't have an honest referee that can comply with the rules,
even outside Connecticut, boil it all down. Even if we went outside Connecticut,
I disagree with all.
All right, let's hear Andrew on the question here. Can we pool resources outside Connecticut, manifest the change from outside, and bring it here?
From outside of Connecticut, everybody's forgetting what this is all about and how this whole thing is built. I mean, I'm not trying to get people to believe in God, okay, when I make this statement. But so wherever you want to put yourself, okay, the power came from God, then it came to us, the people. Okay, if you don't believe in God, then no God, you the people. The people. We are the sovereigns. We are the kings and the queens, or whatever you want to call yourself, because I don't know, I'm not very good with the woke stuff, okay? You're the one with the authority. We're the ones, it's the states that enable the federal government. It all comes from the bottom up. That's what everybody is missing. See, you have more power in a courtroom than an attorney does. A judge cannot affect your livelihood. This is why these attorneys are going to do what a judge says. A judge in your, let's say he wins a case, or for example, an attorney really challenges a judge and pisses him off. See Norm Pattis, who pissed off a bullshit Alex.
I've experienced this firsthand.
No,
lawyer.
Time out. Anything, when you have something that is a closed system, it's a system. They have a closed system of corruption.
It's a guillotine.
Outside of that system is very much a problem. And when you come in and you're you challenge it and you basically punch holes in their system with the law, they really get upset. You want to hear an interesting fact? And I can't remember the exact thing, so somebody can look this up. But this is a mind-blowing fact for me. Ready? There are either 5 or 3 law schools in the entire country that teach constitutional law. 3 or 5, I can't remember which. And by the way, it's not a requirement for a law degree. And actually, I believe at Harvard, it may not even be taught in the law department. So you sit there and you say to yourself, wait a minute, the supreme law of the land is not taught to lawyers? So lawyers do not even understand the Constitution and everything around it and about it, which, by the way, means all those judges don't either. Because that means there's a very few people that actually go and take the course on constitutional law, just that law. And that is frightening. So my take on all this is they don't know, okay? The playing field is very level when you start to use constitutional law. You know it as well as they do. And by the way, things that people should know about doing stuff and representing themselves, listen, you're not a lawyer. Take advantage of it. Don't worry about offending anyone. Don't worry. Oh, I wasn't supposed to say that, Your Honor. I'm sorry.
Right. The one advantage we have, I think why the system is so fearful of us.
It doesn't. No. The reason they're scared is because they're criminals. These are criminals.
Well, yes, there's that, but we're not afraid to ruffle the feathers. Yeah. We don't have to work in those courtrooms every day. We don't have to be under the gun and the professional pretend decorum of this institution. We're not bound to.
So then let me get to my point. We the people need to have what is already on the books, trial by jury, by the people, okay? Plain, simple English, that's how the law is supposed to be done. Trial by jury. And also our grand juries are supposed to be by people, okay? And we don't have judges for a judicial review. We have people be the check when there's a judicial review, not a judge. Not a judge reviewing another judge from the club. Just like the same thing with these attorneys. You don't have the bar. What do you have in the bar? You mean the boys from the bar? Literally, the boys from the bar are making a decision about a guy that,
You know what I think is relevant to mention is it's like the courts have become a social justice arena. We've got to protect all of these people who went to law school and paid tens of thousands of dollars and gone into debt.
You asked the question. The question is, we have to grab and take hold of what is our right. Now, listen, what's so interesting here in Connecticut, they did away with sheriffs. Guess what? All that power comes back to us. That power is ours. So now we have the ability to arrest a judge and we have the ability to arrest the governor. And see, they're blowing this off, but no. How it worked was we gave the authority and power to those sheriffs. They don't get to reallocate them. Those powers, when you asked us, the people, to vote them away in the year 2000, they came back to us, the people. They're my power. I'm Sheriff Andy, and I'm arresting 17.
Yeah!
In my case, I'm arresting 17 judges for criminal acts, federal felony acts, violations of the Administrative Procedures Act, so forth and so on. A complete ignorance and Article 6 of the U.S. Constitution, not acknowledging their oath whatsoever, everything about it. And it's like, this is absurd.
Tim,
Andy, Al.
Yeah,
I'm
maybe
done. I'm done.
this
I'm
will
done.
be-
I'm
my
done.
next comment. I'm not looking for an answer, because it might be too deep. It might need a whole nother show. But I pulled up U.S. Code Oaths of Justice and Judges for the federal. I'll just read the.
Send me the link in the private chat. Send me a link. I'll bring it up while you talk about it.
Oh, let me figure out how to do it. Hold on.
Copy paste.
But I'm not
Control-C.
looking for this to become a whole private chat's locked. You got to
Sure. No, I'll let you have your. Shouldn't be
I
locked.
So
Okay, got you.
I'm not trying to wrinkle any feathers here, but I think there's a problem issue that nobody has addressed. I will faithfully and impartially discharge and perform all duties incumbent upon me as / under the Constitution and laws of the United States. So help me God. The last, so help me God. What happens if a judge or a politician gets elected and reads this oath and doesn't believe in God, is not Christian, is something
Yeah, what if
else?
an angry atheist, right? What if an angry atheist who can't even drive through town going, Jesus, I thought there was a separation between church and state. Why do I have to drive by this church? Like, there's people that are completely
there's people
hysterical.
from
What if
other
that guy's a judge?
So when this was written 200 years ago, the majority of the people who were put in office believed in God, and they were.
That's right. Our founding fathers read all
but-
of the
But
religious
this is not
books.
a binding contract for people who don't believe in God. They have nothing to lose to break the law because they
Right, because there's nothing binding there. God is the binding factor, and if you're an atheist or you're a heathen or you're,
Well, I think we
under
need,
a different
I think we need oath reform for multiple religions.
Well,
legislated oath reform. Legislated oath
wait,
reform.
I don't know. I don't know. But if we're up against
No.
somebody who's evil, Andy likes to say evil a lot, which they may be.
Well, I can understand.
Which they
I
may
can
be.
understand
I
why you-
believe in it. But if they don't believe in God, then
Well, hence you're evil. Hence you're
No,
evil. What we
no,
would
but
interpret as
many-
evil is just godless kind of perception.
Many-
I'm sorry to bring up
many-
that. We all need to sleep on.
Oh, that's a very powerful point, Al. To the point of that is a very strong subject for discussion. That could unravel a 90-minute philosophy segment that could stretch into its own sort of series.
I mean, this
on
might be
channel.
the breakdown of our society and why we're in so much trouble right now. Because
Right.
when I was growing up, I was afraid. I was afraid to rob from people. I was afraid. My parents, my grandfather. Don't do this.
And now they're passing laws where you don't even have bond set for that stuff. You could go rob somebody and then be released 45 minutes later.
So
and go
this
rob
is the
somebody
only
else.
contract. This is the only contract that the judges and the politicians are binded upon to do the right by
Well,
us.
then it's the only explanation as to why they keep doing this. Like why they don't care. Why we're suffering so tremendously.
They might not
in
believe
all
they
of
go to
this.
hell if they do something bad. They might like hell.
Yeah, they don't care.
What happens if
They don't care. Maybe they think they're getting 72 virgins when they die.
I'll wrap it up. I just wanted to bring up that point because I've been listening to the Carrie Lake thing and all sorts of things, and if these judges don't honor their oath, and the police officers and all, what do we have? I mean, this is such a there should be a contract.
Well, it begs the question. It begs me back to
help your assets aren't taken by your victims. That should be
Albert. It begs the question. It goes back to my original question. Is there oversight to be had and pooled as a resource to bring back to Connecticut to help us enforce what we're trying to enforce? We don't have power. That's our problem. And we're perceived by the system of power as a threat. If we have in our corner behind us speaking on our behalf as they are so dutifully elected to do, representatives from, say, Washington, D.C.
You're like,
We have to go back to Andrew's point. The people have to start participating, showing up at
on a local level.
Yes. Participating.
yes,
Participating.
Got it.
Like we got people to go to Andrew.
not somebody from somewhere else, because now you're just going.
But the reason you understand why I'm asking, right? Because you're telling me we need to prey on ourselves on a local level. However,
I don't.
the systems and the parameters that we are confined to within our local levels are corrupt.
No,
So how can we gain progress?
We know that. So you have to address it. We've got bad.
We have to become the local government.
Listen,
That's what it
You have
is.
to realize that we live in a state that doesn't verify signatures for voting, and there's one person in every town that says this vote is accurate or not. They don't even look at the signatures. We need to fix so many
That's right.
things.
Ladies and gentlemen, that's a very true statement. In fact, I'll go as far as to say right here on this YouTube channel, with the risk of being censored and deplatformed, the state of Connecticut will deem a living, live, and well registered voter dead if it means rigging the election.
Okay.
And that's it.
I'm not saying any more. I know Andy's getting frustrated at this point. This is going on. Thank you. And thank you, Tyrant Slayer, Timothy. Thank you, Andrew.
I'm trying. I'm doing my best.
Letting me participate. Hopefully we can learn.
Al, I would love to have you on again. There are plenty of topics to discuss. I know you have experience in a great many of fields and legal issues, helping so many people. I know you're a very active member of the community, and I would like to personally thank you on behalf of my audience, who truly does appreciate what I'm doing, for all that you're doing for people. You are an unsung hero in your own right, in the sense that despite the fact that you're not doing anything you're doing publicly, you are privately on a day-to-day basis fighting for everything that people here on YouTube are fighting for. And they can absolutely get behind your cause, which echoes that of Andy and his family and so many other victims in this state who have been totally screwed over and shafted by the weaponized judicial. With that, we'll say so long to Al. Andy, if you'd like to add your closing words to this evening's stream, now is your time to shine, sir. We'd like to have you back again for further updates
Thank you very much.
and more knowledge. I might be a little unorthodox in my approach, and I might have some strange analogies that come out at times, but I think all of these experiences that we're having on our own personal fronts culminate into an overall experience for every American that we're all suffering within on a regular basis, whether we are aware of it at the time or not. These things are going to impact in a very direct way our lives. And it is more important now than ever that people really start giving a shit. It's not about the Jerry Springer moment and the click view and the shock jock headline and the thumbnail with the half naked women here. It's about real scenarios in real life progress. We need to be a force for progress, and that's what we're trying to do here. And I think Andy and Al can provide a tremendous benefit in helping create that. So I thank both of you for being here and taking the time out of your lives to join us here today. And I sincerely appreciate it. I would hope that you would join us again.
Thank you, guys.
All right. Everybody be well, be swell. Have a wonderful evening. And until next time, stay safe out there. Take no guff from the swine. Together, united, there is little we cannot do. And if we can just unite, we'll do many things together. So I bid to you farewell.
Thank you.